Good morning. We'll reconvene the 73rd plenary session of the Administrative Conference. Thank you, everyone, for rejoining us this morning. We'll begin this morning's program with remarks from Paul Ray, the administrator of OIRA. If you don't know what OIRA is, you're probably in the wrong place. I've invited Paul because as OIRA administrator, he is a unique vantage. But I would like to share with you my observation that as the OIRA administrator, Paul has been as dedicated and honorable a public service as anyone who's held that position. And he's as gracious a person as you will find in Washington. Paul, I wish we could welcome you with a round of applause, but that's of course not possible. And so I'll just offer you our profound thanks and invite you to our virtual podium. Paul, I hope we have you on the line.
I just want to say good morning, Matt. This is Paul Verkyle checking in. A little late, but glad to see you all.
Oh, hey guys, this is Paul Ray. Can you hear me now?
Yes, we can. I hope you heard my introduction of you.
I did, and it was incredibly kind and gracious.
Okay,
so thank you. It was very, very good of you. I assume that you have not heard anything else that I've said up until now.
We have not.
Okay, that should be should go on the list of the 10 most frequently said things during 2020. Is have you heard anything I've said up until now? Well. All I'd said so far was just that it's an honor to be with you this morning. I wish it could be in person to see all of you and meet those I haven't met before, and I hope that that all of you and your loved ones are safe and well in this very, very strange and difficult time. I'm joining by phone today, not video, due to some tech issues. So thank you for bearing with me here. My purpose today is really just to thank you. To thank the ACUS's leadership and membership for all the important work that you've accomplished over these last few years, and also to anticipate the equally vital work that you're in the course of carrying out today, including in this plenary. In my time at OIRA, I've had the opportunity and really the pleasure to draw on the research and recommendations provided by ACUS in many of our regulatory reform initiatives. And so I'd like to share just a few ways in which your work has been very helpful. Now, my experience represents only one snapshot, one perspective on the value of ACUS's work. And so the point of these reflections is to illustrate the great value of ACUS's research and recommendations across the entire government by relating how helpful they've been just with respect to OIRA's work. I know my colleagues at all the other agencies and components around the government would have similar stories to share. So let me begin with Executive Order 13891, which, as many of you know, is the President's order on reform of agency guidance practices. The order, as you know, directs agencies to establish central online portals onto which all guidance must be uploaded, to include on each guidance document a disclaimer explaining that it's non-binding, to seek public notice or to seek public comment on significant guidance, and to submit significant guidance for OIRA review. And there's a companion executive order, EU 13892, that explicitly forbids agencies from treating non-compliance with guidance as itself a violation of law. Now, these EOs were driven by a few basic insights. First, guidance can provide valuable information to stakeholders and can promote transparency. It's definitely true. But it may also be used as a de facto, if not de jure, standard to which private party conduct is sometimes held. Even when agencies use guidance appropriately, unsophisticated members of the public may not understand the interpretations and best practices set forth in guidance do not have the force of law. And, quite aside from concerns about use or perception of guidance as binding, the orders are driven by the desire to enhance procedures around guidance, to promote fairness by making guidance more easily accessible to unsophisticated parties, as well as to increase public participation in the creation of guidance. Now, if these concerns and the remedies for them sound familiar, it's because ACUS identified many of them before the President issued the executive orders. Recommendation number 2017-5 which is agency guidance through policy statements, built on previous ACUS publications to draw attention to the fact that the public may perceive guidance to have mandatory effect, and recommended that agencies include a disclaimer informing the public that guidance does not create binding standards, as well as adopt policies to ensure that standards and guidance are not in practice given binding effect. Likewise, Recommendation 2019-3, which is public availability of agency guidance documents, urged agencies to create centralized guidance web pages. I want to thank ACUS for all of your work in fostering the public conversation about the use of guidance and for proposing some of the measures that were eventually incorporated into the executive orders. The next initiative I'd like to highlight is Executive Order 13924, Section 6, which contains a list of 10 norms of enforcement and adjudication and a directive that agencies review and revise their procedures to bring themselves into compliance with these norms. The list includes the principle that the agency, not the citizen, bears the burden of proof, that enforcement actions must be prompt, that agency adjudicators must be independent of enforcement staff, that the government must provide favorable evidence in its possession to the subject of enforcement, and others equally important. A few months ago, OIRA issued an implementing memo setting forth best practices under each of these 10 principles for agencies to consider. So EO 13924 and its implementing memo are basically designed to make enforcement and adjudication more fair, more efficient, and more consistent with American notions of due process and the rule of law. They're less about responding to specific abuses and more about identifying a positive and comprehensive vision for what enforcement and adjudication should look like in America. They're based on one of the great insights of our system of government, that enforcement may be both effective and fair, that we may safeguard our citizens while respecting their rights. Now, ACUS has pursued these values for years. For instance, I'm thinking of ACUS's well-known model rules of adjudication, which seek to establish equitable, efficient, and transparent rules for agency adjudicatory proceedings, the adjudication sourcebook for non-APA adjudication, your work on evidentiary standards for various sorts of agency hearings, and your 2016 recommendation on self-representation in adjudication. I want especially to thank the acting chair for the very helpful comments, Matt, that your office submitted earlier this year in response to the OMB RFI, which we put out in preparation for EO 13924. Your comments were extremely helpful. They focused on, among a couple of other issues, impartiality in adjudication, the appropriateness of using the FRE 403 standard in adjudications, and public availability of agency procedural rules. And these are all topics that we actually did end up addressing in the EO and the memo, and we adopted your recommendations. So thank you for that. I'd be remiss if I didn't spend at least some time discussing the Paperwork Reduction Act, if only because ACUS is just about the only public forum where I can actually get away with discussing it. In 2018, ACUS very helpfully recommended that OIRA provide training on how to obtain form approvals expeditiously under the PRA's processes, which I will admit can sometimes be somewhat confusing. And then ACUS did one better and actually provided a forum for the OIRA team to do that, to provide that training, which I think was very successful. And ACUS also recommended increasing use of generic clearances, which can really cut down on the time and burden of getting each new form approved. And that was good advice that we ended up taking to heart over the last couple of years. So in the couple minutes remaining, I'd like to mention briefly some areas in which I think ACUS's work will be especially valuable in the coming months and years. One ACUS initiative about which I'm particularly excited is the new Council on Federal Agency Adjudication, which was announced just last September, and the timing is perfect because the Council provides this really great opportunity for agencies to share experiences and best practices as the government as a whole seeks to make enforcement and adjudication more fair and efficient in line with the President's recent EO on that topic. A second topic I want to highlight is that of rules on rulemaking. with respect to which I think the plenary just yesterday approved a recommendation. I'm sure this came up in yesterday's proceedings, but some federal agencies during this term have already issued rules on rulemaking, starting with DOT's really excellent regulation put together by Steve Bradbury and his team a few years ago, and continuing into recent months. And so I'm glad to have ACUS's recommendation on that subject, because I think it'll encourage other agencies to issue rules on rulemaking in the coming months and years. And to my mind, that's a really significant win for transparency and rule of law. The third initiative I want to mention is the ongoing project to develop a classification system for guidance. Having spent several months working with agencies to explore how EU 13891 applies to their various types of guidance, I can tell you this project is going to be very, very valuable. And not just for the agencies and for OIRA, but for the public too, which will benefit from being able to compare the types of guidance issued by different agencies, and urge some agencies to benefit from the example of others. Fourth and last, I'm glad ACUS is focusing on the very important topic of use of AI by the government. As many of you know, just a couple weeks ago, the President issued Executive Order 13960, entitled Promoting the Use of Trustworthy Artificial Intelligence in the Federal Government. And that order directs OMB to issue guidance on federal agency use of AI. Now, that's one reason I'm glad that members of the OIRA team have been working with the ACUS Ad Hoc Committee on agency use of AI. They tell me that they've learned a lot from working with the other AI experts from government, academia, and the private sector who are on that ad hoc committee. So thank you all for your great work there. You know, that's really a topic. It's only going to grow in importance in the years to come. So I'm glad you all are engaging on it. I hope you keep doing that in the future. With all these ongoing work streams and many others, I think it's really safe to say that ACUS's research and recommendations will continue to be a tremendous help to the entire federal community, both OIRA and other White House components, as well as all the agencies in the coming years. So again, thank you for your tremendous work on that. And you know, I'd be remiss if I didn't say at this point, thank you especially to Matt and his team, to Reeve as well for their you know, tremendous advice and collaboration over these last couple of years. You know, y'all have always been a source of good counsel and you know, wonderful folks to bounce ideas around with as we pursue regulatory reform. So thank you for that personally. So and with that, Matt, I will toss things back over to you.
Thank you, Paul, so much for joining us. We very much appreciate that you were able to give us some of your time this morning, and I'm sure that all of our members appreciated hearing your remarks. So thank you very much. Are we ready to shift gears to our first recommendation of the morning? Yes? Our first recommendation returns to a subject that ACUS last addressed in 1995, government bid protests. The title of the current proposed recommendation is Government Contract Bid Protests Before Agencies. This recommendation comes to us, this draft recommendation comes to us, proposed recommendation comes to us from the Committee on Administration and Management, which is chaired by Professor Aaron Nielsen. I'd like to thank him first and foremost for so ably chairing the committee meetings on this project as he's done on so many other projects in the past. And I'd also like, of course, to thank Professor Christopher Eukins, excuse me, we've got too many Christophers this year. Christopher Eukins, who goes by Chris Eukins, and Christopher Yu goes by Christopher. In any event, I would like to very much thank Chris Eukins for agreeing to serve as the consultant on this project and doing such an outstanding job. Professor Eukins is no doubt one of the foremost experts on government procurement law, along with several of his colleagues at GW Law School, which has an outstanding faculty on that subject. So what we will do now, as we always do, is hear first from the consultant, Chris Ukins, on his report, and then we'll hear from Aaron on the course of the committee proceedings. Professor Ukins, please.
Thanks very much, and good morning. I'm very honored to be able to participate today with the work of the Administrative Conference. My colleagues at George Washington University Law School, Senior Associate Dean Emily Hammond, Associate Dean Alan Morrison, and Professors Richard Pierce and Jonathan Siegel regularly participate in ACUS, and I've been watching the Administrative Conference's work for many years. I've been a professor at GW teaching in the government procurement law program since 2002. We're the second generation of professors in that program. I've been a practitioner in public procurement law for roughly 30 years, both in the government and in the private sector. For 10 of those years, I was part of the US delegation, which helped reform the United Nations model procurement law, so I have extensive experience in reform efforts of this kind. As a practitioner, I've handled agency level bid protests by a vendor brought directly to the agency, and I worked in the 1990s on an American Bar Association effort to improve agency level bid protests. The ACUS project, in which I'm the expert on agency level bid protests, is perhaps a first for the Administrative Conference because Congress has in essence endorsed ACUS's recommendations before they're finalized. Let me explain. The draft recommendations before you reflect a series of recommendations in the consultant's report. Those recommendations go to key deficiencies in the current rule regarding the process for handling bid protests in an agency, who can bring an agency level bid protest and why, the administrative record to be shared with the vendor during that process, follow-on protests at the Government Accountability Office and the Court of Federal Claims, and administrative oversight within the agencies for transparency and public accountability. Those recommendations reflected extensive discussions within the bar with representatives of agencies and private counsel. The recommendations built on roughly 25 years of innovations in individual agencies, the stepping stones to reform referenced in the title to the consultant's report. The Senate Armed Services Committee took note of the ACUS report in the Senate committee report that originally accompanied the current National Defense Authorization Act. The combined conference report on the National Defense Authorization Act, which has been approved by both houses of Congress, was more detailed. By the way, the National Defense Authorization Act is currently pending signature by the president. The conference report noted the recommendations in the ACUS report and asked that they be given serious consideration when the Defense Department undertakes a broader assessment of bid protests in the coming months. The Defense Department report is due on September 1st. The ACUS report recommendations, which were endorsed by Congress, have been carried into the draft recommendations before you, which I'll be glad to discuss with you. Thank you again for this opportunity to serve the Administrative Conference.
Thank you, Chris. We'll hear from Aaron now. Aaron, please.
Sure, thank you. So I want to begin by expressing my gratitude towards Chris. Usually when a project comes to my committee, I have at least some sense for how things work. This was all new to me, and I learned a lot from Chris. I've learned a lot from the expertise of my committee. So we were the guinea pig of the online committee process. We were the first one. We did this back in July, and we had 2 meetings about this for the committee. And because this is something that matters so much to a lot of different agencies, and maybe not be in the wheelhouse of every member of the conference, we reached out extensively to make sure we got feedback and contributions from experts in the field, including Chris. We also reached out to the former Deputy General Counsel of Acquisition at the Air Force, the former Chief of Protests at the Army, and the current Chief of Protests at the Army. And we've tried, we reached out to OPM to try to get as much feedback as we could about this process to make sure that, people know that it's coming and that we have up-to-date current best practices from across the government. And that's where we end today. We'll see, a number of proposed amendments from the council and from Robert Gerard, who's a member of our committee. And those are, at least from my perspective, very much consistent with what the committee is trying to do.
Thank you very much, Aaron, and thank you again, Chris. We'll turn first to the manager's amendment. I need the Zoom chat up on the screen, please. Unless I'm missing something here. Thank you, Jeremy. I appreciate that. Okay, is there any objection to the manager's amendment? Without objection, the manager's amendment is adopted. I do see on my screen our former chairman, Paul Verkyle. I'd like to welcome and acknowledge him now. Hello, Paul.
Hello, hi, Matt. Great job you're doing.
Thank
Good
you,
to see you,
Paul.
Paul.
It's
Hope
good
we
to
can
see.
do the next one in live territory.
I do too. You look well, and we're glad to see you. Thank you, Paul.
Thank you.
Is there general discussion on the proposed recommendation? Does anybody wish to be recognized? All right, I don't see anyone who seeks recognition, so what we'll do is turn to the first council amendment. And Ron Cass, I hope you're standing by because I'm going to turn to you on these. I think some of these actually came off your pen in the first instance. The first council amendment appears Reeve, you want to help me out here? Just bear with me for a second. This is not lining up with the red line, correct? The paper in the packets?
It's this one here.
But paragraph 4 is not showing. Is that just because? All right, pardon me, the pagination is off on the copy that I have in front of me. We'll turn to the first council amendment, which is reflected on the screen at lines 108 through 112. Let me turn to Ron Cass to explain the amendment if Ron is willing to do that. Ron, may I turn to you?
I'm happy to explain. The way the language read earlier,
Pagination.
it looked as if agencies were not required to say at the outset by rule how long they would take before they would deem a protest denied. And rather than have that be a case-by-case determination, we thought it was better for the agencies to say by rule how long the process would take before a protest could be deemed denied. If they have to do that on a class-by-class basis among different categories of procurement, they should specify what the criteria are for different classes. And if they need to make a change in individual cases, they should specify in the rule what the criteria are for making those changes. And the reason behind this was a sense that that would be better for people dealing with the agency. It would provide some certainty. It would let people dealing with the agency know at what point they were appropriately moving on to the next level of protest or challenge.
Thank you, Ron. Let me turn to Aaron to see if he has any response to the council amendment. And if not Aaron, then Chris Hukins.
So I don't have any objection to this. I think it's a helpful amendment. I confess, though, that this didn't get run through the committee, so the committee might disagree on that. But to me, I agree with Ron. I think Ron's explanation is spot on.
Looks fine.
Is there any objection to the council amendment? Or without objection, the council amendment, the first council amendment is adopted. The next council amendment appears on what's now lines, it's the paragraph 9. On line 125, and it would add in a parenthetical subject to potential override in urgent and compelling circumstances. Ron, may I turn back to you on this one? Ron
Certainly.
Capps?
Yes, the thinking of the council on this one was that there may be circumstances in which you actually need to get a contract let. You could have, for instance, we've just been through the COVID emergency with a lot of activity going on both in and out of government. And the thought of the council was that there may be times when a contract has to proceed, and we thought that should be provided for in the rules.
Aaron, response? Aaron Nielsen?
Yeah, again, this did not come up during the committee process. I see no objection to it. I think it's a helpful amendment. But again, my committee might disagree, but it strikes me as very helpful.
We'll see if anyone disagrees, but first let's turn to Professor Eukins. Chris?
You can just see in the margins, the amendment is very sound. It aligns this recommendation with the practice under statute before the Government Accountability Office. A reference to 31 USC 3553 is a reference to the fact that there can be an agency override in a GAO protest as well if there are urgent and compelling circumstances.
Okay. Is there any objection to the council amendment? Without objection, the second council amendment is adopted. Now we're going to turn to other pre-submitted amendments. Robert Gerard of the Office of Personnel Management has quite a few of them. Before turning to Rob Gerard, I just want to ask Aaron Nielsen whether, if he recalls, whether any of the amendments that are in the markup, other than the council amendments we've just dealt with, were addressed at all during the committee meetings?
Robert's amendment, proposed amendments, or all?
Yeah, Robert's proposed amendments. Were any of these addressed?
I don't believe so. Robert is a member of the committee, and he was there and very, very helpful in the first meeting. He wasn't, as I recall, wasn't able to join us for the second meeting.
Okay.
So I don't believe so. And I will say, just before we get started, I don't have an objection to any of them. I think all of them are helpful.
Okay.
And they come from OPM.
All right. Thank you. I just wanted to check in with you to make sure, to see whether they had been debated, so I don't have to ask you on each one of them. So with that, I'm just going to go in sequence here and start with Robert Gerard. I'll recognize Robert Gerard, and we'll first consider Gerard Amendment number 1. What's been marked Gerard number 1 on the red line in your packets and on the screen. Rob?
Thank you, Matt. And these recommendations actually come from OPM's new Senior Procurement Counsel, James Metzel. And unfortunately, I did not have the benefit of his advice at the time that we did the committee meetings. And so I'm sorry to burden the Assembly with so many pre-submitted amendments. So the first proposed amendment is to add to footnote 1, which currently references the Competition and Contracting Act. We think that it would be important to reference the other significant recent procurement legislation that determines how agencies procure commercial items and information technology.
May I turn to Chris Eukins for his perspective on this proposed amendment?
As with the other recommendations from James Metzel, I thought that they were technically correct and quite sound. And just on a blanket basis, I think they were very good. As a practical matter, I reached out to James. He sent me a nice note, and there's going to be a next step in this process, which is to talk to the acquisition reform body. It's a research body that's funded by the Defense Department. Talk to them about the report that they're putting together. And I'm looking forward to having James participate in that conversation. He and other agency counsel will be important voices in talking about the next steps in reform for the report that's due to the Armed Services Committees on September 1st.
Okay, but you, with respect to this, the First Amendment, you think it's sound. I'm just going to go through each one of them, and hopefully we can dispense with them quickly. But with respect to number one, you think that is a sound amendment?
Yes.
Okay. Is there any objection to Gerard Amendment number one? Without objection, Gerard Amendment number one is adopted. We'll turn now to Gerard Amendment number two, also on the first page, and I'll turn back to Rob Gerard on that amendment.
Sure. This is just adding some text to define what we mean by acquisitions. Since the federal acquisition regulation does not cover all acquisitions, we felt that it would be important to specify what it does cover. It could either be in the body of the text, or it could be dropped as a footnote after acquisitions to state that the term acquisitions as used in this recommendation refers to acquisitions of supplies and services with appropriated funds by and for the use of the federal government.
Do you have a preference? I'm sorry.
I think that I think that it might be preferable as a footnote because it's a bit busy.
Aaron, do you have a perspective on the placement of this clause, assuming you don't otherwise object to it?
I don't object to it. My preference is in the body text. I think it reads well, but I will never, I'm an academic. I will never fight adding a footnote.
I will fight adding a footnote. So why don't we, does anyone wish to be heard on the second Gerard Amendment before we take a vote on it? And we'll take a vote on the amendment as it appears now, that is in the text. Ron Cass seems to like it in the text. I always prefer the text myself. Jack Bierman, do you wish to be recognized?
Yes, I just want to say I agree with Ron. It's better in the text.
Okay, that's helpful. Thank you. Is there any objection to the adoption of Gerard Amendment number two? Without objection, Gerard Amendment number two is adopted. We'll now turn to Gerard Amendment number three, which appears in footnote 4. And once again, I'll recognize Rob Gerard.
Sure. Since the body of the text states that interested parties may file bid protests, the footnote just qualifies this by explaining that there are exceptions under statute and regulation where an interested party, situations where an interested party is not permitted to do so.
Okay. Let me turn back to Chris Hukins to see what his position is on this amendment.
It's fine.
And Aaron Nielsen, you are fine with it as well. Do you support it, Aaron?
I do.
Okay. Is there any debate? Does anybody wish to be heard on Gerard number three? Without objection, Gerard number three is adopted. Now we'll turn to Gerard Amendment number 4. And again, I will turn back to Rob Gerard.
Okay, so the body of the text of the preamble states that a vendor may file a bid protest in any of 3 forums. The footnote just qualifies this by noting an area where a vendor does not have the option to file at the agency level, but must file at GAO.
Chris Hukins?
No objection.
And Aaron, you support this amendment?
Chris says it's accurate, so I see no harm in it. So sure.
So if Chris says it, Ron Cass wishes to be recognized.
I have a major substantive issue here. I think the and before number 3 should be an or.
I agree. Does anybody disagree? And will become or. And the amendment is adopted. Now we're on Jeff's. All right, Rob, you can take a well-earned break for a second, and we're going to turn now to Jeff Lubbers, who has a comment on page 2 at line, what is now line, or lines 15 through 17. Jeff, Jeff Lubbers is recognized.
Thank you, Matt. Good morning, everyone. My comments are much less well-informed than Robert's. In fact, they're coming from a point of ignorance. So when I read this cold without, I admit, reading the report, I just thought it was a little bit confusing in terms of whether or not these, we changed and or, but can a vendor file in more than one of the 3 forums? Are they mutually exclusive? Can they first file in one and then if they lose there, file in another? What about judicial review? I realize I'm asking a lot of questions here, but it seemed like if there's an easy way to make that clear here, I would like to have it done. I noticed later on in lines 65, 67, we do explain that you can appeal from the agency to the GAO. But so I'm just kind of asking a question here, and most of my comments are in this vein.
Let me before turning to Aaron and Chris, because I think this subject was discussed during the committee meeting, let me turn to Alan Morrison, who would like to be recognized on Jeff's comment. Alan, you're recognized.
Thank you, Matt. Good morning, everybody. I agree fully with Jeff, and I think this is an important matter that ought to be dealt with in the preamble upfront, explaining to those like Jeff and myself who are not familiar with bid protests, whether these are exclusive and whether you can go from one into the other. And I think it's important, not just for informational purposes, but because if there are additional procedures that are available to bid protesters after they go to the agency, it makes it much more reasonable for people to have to go to the agency first and expect the agency to take care of the matter. And therefore, I think it strengthens the recommendation. I do not know what the answer to Jeff's questions are, but I think that that can be taken care of and should be taken care of in the preamble. Thanks.
Let me turn to Aaron first, and then to Chris. Aaron, do you have any response to Jeff's comment?
I think that it is a helpful comment. I confess that during the committee process, it was explained to us by Chris how it works. And I think, we just kind of internalized it. And I'm looking now, I guess if you didn't go through that process, it's not as obvious. I'm happy to let Chris, explain, but my understanding is that you can go to any of the 3 forums, but typically you would do so kind of in an ascending way. You would start at the agency or maybe skip directly to GAO and then go up to the Court of Federal Claims. But, so no one goes directly to the Court of Federal Claims first, or very rarely. That's my understanding. So that's how we kind of structured it this way. But Chris really is the expert on that.
Let me turn to you, Chris, and then I see that Jack Bierman wishes to be recognized on this matter. Chris?
So a practical suggestion would be that this is discussed in the consultant's report in some detail. If you wanted to be able to appropriate text, you could just use that text from the consultant's report here to lay out the various options. The doctrinal response, the legal response is that you can go from agency, then a follow on to GAO, and then conceivably even go to the Court of Federal Claims. It's important to Alan's point, it's important to stress that there is not an exhaustion requirement and that you don't have to go to the agency first. And the USPS, the US Postal Service, which is outside the Federal Acquisition Regulation, does have an exhaustion requirement. You have to go to the contracting officer first. And that is generally viewed with disfavor in the community because in essence, it's forcing the contractor to spend very precious resources going to what could be a very adversarial forum. So an exhaustion requirement would really be something we'd want to avoid.
Jack Bierman is recognized.
Yeah, I want to sort of join in the critique of this because once someone's got some stuff playing in the background that's disturbing. Okay.
We're working on it, Jack.
Yeah. Once the amendment was offered, which dropped the footnote, which made any not true, I got uncomfortable with that language because it's a sort of like when you go to the store when they say everything's on sale and then there's a tiny little footnote and you don't know it and what the thing you want, of course, is not on sale. So I think that this text needs to be rewritten. And I'm because I have no expertise on this, I don't want to offer any language, but it needs to be rewritten. Something like there are 3 forums available for bid protests, and that that may have different procedural requirements or something like that, and then identify them all the way we've identified them, which I think is fine. But I think it needs that phrase in any of 3 forums is misleading and incorrect now. And I think there needs to be some work on this.
Chris, if I may turn to you, and I hate to put you on the spot here, but do you have a suggestion as to how this could be redrafted, if it can be easily redrafted?
You mean to lay out how the options unfold? Is that the question?
Correct.
Yeah, we could go on to the next amendment and then come back, and I could draft language and put it into the chat if that's useful.
No, I don't want to put language into the chat. Aaron, do you have a suggestion here? Let's come back to this at the end because there's no language on the table here. Let's come back to this to the end. We may need to send this to the Committee on Style with some general drafting guidelines here because otherwise it's going to, I think, take up too much of our time. So with that, I'm going to move to the next amendment. Actually, it is an amendment from Alan Morrison, and I'll turn to Alan now, who's got the Supreme Court behind him. Alan?
Yes. Where are we, Matt? I'm sorry. My phone just rang.
Do you wish to be recognized?
Oh yeah.
Alan?
Okay. I see the amendment. Yes. I think this is not a matter of great substance. I don't think this is a question of bias as we normally think of the word bias. I think it's an arguable conflict of interest. But it's a perception of prejudgment, rather like what Chris talked about before a moment ago. I don't think this is a matter of substance, but I think that the conflict of interest is typically thought of. It's not that nobody has an economic interest. It's a question of prejudgment. Thanks.
Aaron, comments on the Morrison amendment?
I like the Morrison amendment. I like the original language. I am indifferent between the two. I think both are getting at the same point.
Okay, I'd like to recognize John Duffy now. John? John, are you there? All right, I'm going to move on then. If we can get John up, we will do that. Let's turn to the next amendment, actually a comment, and that's from Jeff Lubbers. It's Lubbers comment number 2 on page 4. You know what? Let's back up. I did not. I got confused because with the John Duffy John Duffy's seeking of recognition, which we were unable to, and we were unable to connect him.
Can you hear
So-
me now? Can you hear me
Yes,
now?
I can. Yes, I can, John, please. You wish to be heard on Alan's amendment or something else?
On Alan's amendment, please.
Okay, please.
So I support Alan's amendment, but I think the word bias is used at the beginning of that paragraph, first sentence, last word. I think that it needs to be changed too, because I think throwing around charges of bias, I think are not correct in this context. I think some language such as because they perceive the agency as unlikely to change its decision, something like that would be consistent with Alan's amendment, and I think would take away the, I think, inaccurate assertion of agency bias, which I don't think is, which I agree is the substance of Alan's comment. Thank you.
Alan, on that point, on John's comment?
I agree with John.
All right, so John, would you like to move this as an amendment? Alan may not do so because he's a senior fellow.
Yes, I will move the language that is on the screen, which is my language in green, and also I will also move Alan Morrison's amendment. If I mean, Chris Ukins, I'd like to hear what the drafters think about this, but I do think it's right, and I will move it as amendment.
Chris, do you have any concerns with Alan Morrison, what's now John Duffy's amendment appearing on lines 33 through 38?
That's fine. Thank you, John.
Okay. Is there any Susan Braden, Judge Braden wishes to be recognized. If it's on this point, I'll recognize her. If not, I will recognize her after we deal with this amendment. Susan, Judge Braden?
Yes, I was trying to get in earlier to respond to Jeff Lubbers, but I'll wait.
Okay. Is there any objection to the adoption of the Duffy amendment, which appears on lines 34, 36, and 37 of the version on the screen? All right, without objection, the Duffy amendment is adopted. Now let's move to, I am going to come back to the issue we were previously discussing and the issue on which Susan Braden seeks recognition. But for now, I want to move on to Jeff Lubbers' next comment, number 2, which appears on page 4. Jeff Lubbers is recognized.
Thank you, Matt. And Susan can probably answer this. My simple question, whether the vendors who file at the COFC have the same right to demand to see the entire record. Chris probably knows.
Chris Ukins, could you respond to Jeff Lubbers?
Sure, it's in there. So Jeff, the answer is yes, and the Court of Federal Claims in its special appendix on bid protests in Roman Part 7 lays out exactly what can be requested. And in some ways is actually better than GAO because it has more detail than the GAO direction.
In that case, I would suggest saying at GAO or the COFC.
Chris?
The practical problem there is that the rest of the sentence refers to a back and forth that's governed by the GAO rules. We might want to just drop a footnote saying that there can be a similar demand for that the administrative record is produced as a matter of is presumptively produced in the Court of Federal Claims, and then give a citation to the appendix to the COFC rules.
Jeff?
That would be fine with me.
Can we get the language up on the screen, if possible, Mark? I know this is difficult.
Chris, you can please repeat your.
Sure. The administrative record is presumptively produced in bid protests brought before the COFC per the court's appendix to its rules regarding bid protests, comma, part in Roman 7. I know all this because I'm publishing my report as an article and I had to proofread it overnight. So 4 o'clock in the morning, I learned it's Roman 7.
I'm happy to be your straight man.
Would this language be better in the text or in a footnote?
I recommended it for the footnote just because the text really refers to it's a very close pirouette under the GAO rules in the text. And so it's be a little confusing to try to put them both together.
Aaron, there are 2 members who appear to prefer that this language be put in the text. May I ask your opinion on it?
Sure. My preference probably would be not to include it at all, but if we're going to include it, I would put it in a footnote. I don't feel strongly one way or the other. I don't think this recommendation is supposed to be a treatise on all of the ins and outs of all the levels. But if we're going to have it, I would put it in a footnote.
Is Ron Levin, do you wish to be recognized on this point?
No, I had in mind the previous point, Morris and Duffy, but it was minor and somewhat belated, so I'll just pass.
Okay. So we have a proposed amendment up on the screen in footnote 18. Is there a voting member who wishes to move this as an amendment? Hearing none, we'll move on to proposed amendment number 5, Gerard amendment number 5. Susan, let me just recognize Susan Braden for one moment. Susan, can we? I'll recognize you. Do you wish to be recognized, or were you just putting a comment in the chat function in the chat?
Can you hear me?
Yes. Do you wish to be recognized?
Yes, it's not to take up presumptively. It is.
Well, there's no amendment, so we'll move on to Gerard number 5. Robert Gerard is recognized.
Thank you. So the text currently states that a procuring agency must respond to a request for the record within 30 days. I'm proposing a clarifying change because under GAO's regulation, or CFR 21.3C, and a corresponding FAR provision, an agency must produce the record within 30 days, but must respond to the request at least 5 days prior to producing it. Now that being said, the regulation it's quite nuanced, and so if I'm oversimplifying things with the amendment, I'd certainly appreciate some clarifying amendments.
Let's turn to Chris Yu on this one first. Chris? Yukins, I'm sorry.
That's fine.
My apologies.
No, the amendment looks fine. After 25 days, the protester gets from the agency what's essentially a privilege log, and that's fine. It's just giving more definition here. I think the amendment's fine.
And this looks good to you, Aaron?
Thumbs up.
Is there any objection to the adoption of Gerard amendment number 5? Without objection, Gerard amendment number 5 is adopted. The next, Gerard amendment number 6, appears to me just to be the addition of a subsection citation in footnote 18. Is that correct?
Right. I just added a citation to paragraph C of the regulation because that's the paragraph that actually specifies the time limits for an agency's response.
Chris, is that correct, the citation?
Yep.
Okay, without objection, Gerard amendment number 6 is adopted. We'll go on to the next item, which is a comment from Jeff Lubbers, is Lubbers number 3. I'll turn to you now, Jeff.
Yes, I just wondered what the term valid meant there. It appears twice in those three lines. Does it mean that just as the filing of an agency level protest automatically prohibits, et cetera? Is it the filing of it, or does it have to be deemed to be valid before that happens? If it's just, I would just say that's the filing.
Yeah, I went back and Jeff, I went back and looked at the rule, and it's just as the filing. It's just if it was a facially invalid, there's some kooks in the community. If they file a protest, the agency will second guess it. But it could be facially valid, but we could take out valid entirely.
Is there an amendment from a voting member here? Does anybody?
My suggestion would just be to say, just as the filing of an agency level protest. But I can't offer that myself, so.
Well, Aaron, what is your position on the amendment Jeff Lubbers has just proposed?
I like it. I think it makes sense. I'm happy to move it.
Okay. Is there any objection to that amendment? All right. Without objection, that amendment is adopted. Now we'll turn to, also on the same page and in the same paragraph, we'll turn back to Robert Gerard to speak on Gerard Amendment number 7. Rob?
Sure, and I see that this actually covers 2 lines here, line 73 and 75, but it's similar. The current text refers to a stay. What we were trying to do here is to mention that the stay more specifically is to prevent the contract from being awarded if it's a pre-award bid protest, or to prevent it from being performed if it's a post-award protest.
And may I turn to Chris Eukins for his perspective on this amendment, number 7?
That looks great. Now you know why I want Robert's colleague James on my team as we fight this out over the next few months with DOD. He's a great.
Is there any objection to Gerard Amendment number 7? Without objection, Gerard Amendment number 7 is adopted. We'll move on now to Rob Gerard's next amendment, Gerard number 8, and I'll recognize Rob once more.
Sure, this actually is in conformity with Council Amendment 2 later on, which was already adopted. It recognizes that even if an agency protest is received, contractor award or performance can still be justified for urgent or compelling reasons, or if in the best interest of the government.
Aaron, no objection?
No objection.
Without objection, Gerard Amendment number 8 is adopted. Now we'll turn to the next item, which is another comment from Jeff Lubbers, Lubbers number 3. Already addressed, excuse me. I see. So now we go to Gerard number 9. Okay, so Gerard number 9, we're still on the same page. It's a change to footnote 24. Is that correct, Reeve? Rob, I'll recognize you on Gerard number 9.
Thank you. This also is in conformity with Council Amendment number 2, and the citations we added a permit, award, or performance despite a GAO bid protest if there are urgent and compelling circumstances.
Chris, your perspective on Gerard's amendment, Rob Gerard's amendment, Gerard number 9?
Looks fine.
Aaron?
Thumbs up.
Is there any objection to the adoption of Gerard Amendment number 9? Without objection, it is adopted. Now we'll move to Jeff Lubbers has a comment on, if we're on page 7, or starts on page 6 actually, the subsection entitled Notice of the Timeliness for Agency Level Protest. Jeff Lubbers has a comment there, and I'll turn to Jeff and recognize Jeff.
Thank you. I was just wondering why these recommendations directed at the agencies shouldn't be directed to the amending the FAR itself.
May I turn to Chris Eukins on that to respond to Jeff?
Sure. So Jeff, in the underlying consultants report, I did recommend that it either go through the FAR or go through agency amendments. Just to lay it out for you, how it's likely to unfold politically over the next few months. So the Defense Department will publish a broader report, or a center that is funded by the Defense Department will publish a broader report, which will include the ACUS recommendations regarding agency level bid protests. The Senate and the House Armed Services Committees have signaled that they want these recommendations included in that report, and they're likely to embrace it. The next step, it will go back at that point to the Armed Services Committees, and the Armed Services Committees in the next iteration of the National Defense Authorization Act, they received the report on September 1st. The next iteration will be moving through committee at that point, and will be probably reach the floors of the Senate and the House in late 2021. And in that process, the Armed Services Committee staff and the committees themselves are likely to call for a FAR case that sweeps up those amendments recommended by the DoD report. So it's, as a practical matter, Jeff, to your point, it's very likely this will all be affected through through FAR amendments, and those FAR amendments might take anywhere between 12 and 18 months.
Aaron, are there any thoughts you have on this point?
So we did discuss this. The first draft of the recommendations had broader, and we said you can either do it by agency or for the FAR, or Congress could just enact new legislation altogether. And we had a lengthy discussion in the committee about that. We ended up not doing it that way, being more specific about who we were asking to do things, and we didn't recommend a change to the FAR here. That was a little bit too ambitious, I think, for the committee. It's a broader change, and then you put the overlay of things that are happening outside of us. But I think the committee's view was, let's just kind of keep this targeted at the agencies.
Jeff, anything further on this?
Well, obviously, I'll defer to the experts. I would note that recommendation 9 is directed to Congress, and that's the only one that is. And so,
correct.
Is there a reason that you wanted to go to Congress on that one, not on
Aaron?
Yes, we did discuss that, and that was one that, as I recall, that it would take Congress to do.
And Jeff, the reason to do that, we referenced before a section within 31 USC, I think it was 3553, and the most elegant way of accomplishing paragraph 9 would be through a statutory reform to section 3553 of Title 31. That's why there's a reference there to Congress. But in principle, it could be done through a FAR change as well, telling the agencies to respect a stay after an agency level bid protest while a GAO protest is underway.
Does anyone have anything further on Jeff's comment before we move on? All right, we'll move on to Gerard Amendment number 7, which is on page 7. Rob, I'll recognize you again to identify and discuss your amendment number 7.
Yes, this is it's just it's the same as Amendment 7 on line 73 and 75.
Any objection, Aaron?
Nope, for the same reason I liked it earlier, it's fine here too.
Without objection, Gerard Amendment number 7 is adopted. Now, Reeve, I'm going to Gerard 10 here.
And yeah, one more step.
All right, so all right, I'm sorry. That's the same amendment number 7. So I just did that twice, and I should have skipped that. I got it. All right, my apologies. We've already addressed that, and thank you, Aaron, for reminding me of that. We'll go to Gerard Amendment number 10, which now appears on line 116 through 17. Rob, you're recognized on number 10.
Sure. So the recommendation as currently written is for agencies to give a short extension of a stay after a final decision in an agency level bid protest. The purpose of the amendment is to just remind agencies that they're already permitted to do this by regulation under section 33.103 F4 of the FAR. So we think that this will provide encouragement for agencies to follow the recommendation, knowing that they're already permitted to do it.
Chris, you're okay with this amendment?
Absolutely.
Okay, absolutely. And if you're absolutely fine with it, I assume Aaron is at least fine with it.
I am at least fine with it. A friendly amendment might be to say as permitted by the FAR, because by regulation, it's unclear if that's agency-specific regulation or what we're talking about.
Rob Gerard, are you okay with Aaron's modification of your amendment?
Yes, I didn't want to put in the specific citation. I thought that would be too technical, but I think to reference the FAR itself is a good change.
All right. Is there any objection to Gerard Amendment number 10 as modified? Without objection, Gerard Amendment number 10 is adopted. 7, again, we've already dispensed with, Reeve, correct? So now we go back to Jeff Lubbers for Lubbers comment number 5. Jeff, you're recognized.
Well, you've already answered the point about Congress. My other question was whether or not it should also apply if a protester promptly files a protest at the COFC, if they can jump from the agency to the COFC.
Let me turn again to Chris Eukins. Chris?
So the legal answer to your question, Jeff, is that the COFC has the equitable power to stop the procurement. The practical answer is the Justice Department usually chickens out and just gets the agency to agree to a voluntary stay.
Unfortunately, the Justice Department spot at ACUS is unfilled, so DOJ will not be able to respond to your characterization.
So
Jeff,
it's not worth making any changes, I guess. Is that your, Chris?
Is that your suggestion, Chris?
Yes, that would be my suggestion, yeah.
And are you happy, Jeff, with Chris's suggestion?
I'm willing to defer to it, of course.
Okay, that's terrific. So we'll move on now to Gerard Amendment number 11. And that appears on page 8. No, it appears on page 9. Excuse me, it appears on page 7, excuse me. Let me turn to Rob Gerard again to address this time Gerard Amendment number 12.
Sure. So recommendation 11 is to conform agency reporting requirements for bid protest metrics the same way that GAO reports to furnish some uniformity. Since GAO's annual report to Congress reports on the percentage of protests closed in the fiscal year, the purpose of amendments 11 and 12 would likewise have agencies reporting on a fiscal year basis. That being said, we did have a comment. James pointed out that although this would allow apples to apples comparisons between agency reporting and GAO reporting, it would also import what might be a deficiency in the way that GAO reports things. There's a lot of bid protests in the fourth quarter of a fiscal year that aren't resolved until first quarter of the next fiscal year. So you don't really get a sense from GAO's reporting of the end-to-end timeliness of resolution of bid protests because they're only reporting the fiscal year when it was closed.
Let me turn to Chris on this, on Gerard 11, 12, and then the accompanying comment. Chris?
Chris is muted.
I'm sorry. I'll defer to Rob on this in terms of perhaps adding the more detail. I should just say that what became clear during our discussions, especially with the Defense Department Council, most particularly with the Air Force Council, is that they view the agency level bid protests as a management tool. They actually want the data to be reported internally so they can see where there are problems arising. And so they might have annual reports that have much more detail. The GAO reports, in contrast, are GAO is really a report card that GAO is giving to Congress every year. So the reports are for a different purpose. The bottom line of what I'm suggesting is the more open we leave this, the better, because I think during the discussion that'll occur over the next few months with the agencies will say, and I don't know what the answer to this question is, but the agencies will say, we can report this, this, and this easily, and that information would be very useful as a management tool for us internally.
I'd like to recognize Ron Cass for a moment on these amendments here. I think he has a comment. If you
Yes,
don't, Ron, tell me so.
No, I just wondered whether the last two, although I think all the prior amendments were helpful, I wonder whether the last couple of changes here are necessary. If we're saying report annually, we don't need to specify whether it's on a fiscal year basis or not. I think that could be left to people who want to really micromanage this. I think from the agencies, from the ACUS standpoint, the idea is to have an annual reporting. It doesn't matter really to us whether it is on a fiscal or other basis. And if the reporting changes in the way it's handled, I don't think our report really should be geared to that.
I'll turn back to Rob. Has Ron persuaded you to withdraw these amendments? If you do, you can walk away with 1,000 batting average here, but it's entirely up to you.
Yeah, I think that Ron's comment combined with Chris's comment that really agencies are using this as a management scorecard, which in some cases might be even more detailed than what GAO is furnishing to Congress. As long as we have some minimum benchmarks that allow comparisons, and I think we do with this recommendation, I'd be fine with withdrawing 11 and 12 related to fiscal year reporting.
Okay, well, thank you very much. Thanks, Rob, and thanks for your really searching review of this recommendation, and your colleagues as well. Obviously, you were on point with respect to every item, and we appreciate it very much. I am going to turn back in a moment to the language the issue we skipped over, and that is the relationship among the dispute resolution procedures in the three forums, including the Court of Federal Claims. Before I return to that issue, though, I want to ask if any other voting members have any amendments that they wish to move from the floor unrelated to the issue I just mentioned.
Matt, can I be?
Yes. Just hold on for 1 second, John. Mark Thompson is reminding me that Rob's last comment at the end of page, I don't know if it's 7 or 8, has not been addressed. Rob, do you wish to be recognized once more?
Sure. This wasn't an amendment, but rather it was a comment that mentioned by James, which is that if we are going to recommend that agencies report on the average time required for a bid protest, that's somewhat different than what GAO does in its reports to Congress, which is to report on cases resolved within 100 days. So in other words, there wouldn't be exact conformity between what GAO's practice is and what we think the agency best practice should be.
Is there a suggested amendment here?
I don't have.
Could I offer one?
Ron Cass is recognized, yes.
Could we just delete the word average? And say the time required for bid protests to be resolved, and that will let them use either an average figure or a 100-day figure. It gives some flexibility in what is actually reported.
Rob?
I think that's a good edit.
Okay.
It shouldn't be for a bid protest. It should be for bid protests.
And Aaron, as our committee chair, you have no objection to that Cass amendment?
I don't, especially if we make a bid protest, so it's clear that we're not talking about individuals.
Okay, so without objection, the Cass amendment is adopted. I'm going to now recognize, thank you again, Rob. I'm sorry that I skipped over your last comment. And thanks, Mark, for reminding me. I'm going to recognize now John Duffy. John?
Thank you. So my comment goes to page or line 68, but it may be a little earlier, like 65, paragraph beginning the perception. You were just past it. There you go. The perception that agency level protests. I was a little worried about the word mistrust later on in this sentence because again, it suggests bias, but I realized that there's a confusion here because all the past paragraphs talk about why people don't file at the agency. And I think this switches gears. Is that right? This is actually directed not to vendors who lose at the agency. This is directed to people who actually do file at the agency, do file a protest. Is that correct? Because if that's correct, I misread it originally. And it just seems jarring and hard to I have a few suggestions to clarify. Is this for people who actually do file these protests at the agency?
Why don't we turn to Chris Ukins to respond to John. Chris?
Yeah, John, that is correct. The concern is that an agency level bid protest, as a practical matter, and it's happened to me in the past as a practitioner, that it leaves a very bad taste in the mouth of the agency level protester, the vendor, and as a result, they just don't use it again. It's bad enough so that that outside counsel are reluctant even to recommend agency level bid protests, because if things go badly awry, and they do, and under the current process, their outside counsel are concerned about a possible malpractice claim.
So I do have two suggestions just to make this clear, because the first suggestion is to insert the word also between accountability and makes. And then later say that more likely that protesters who, and insert the words, do file at the agency level and lose. And the reason here is just to make clear that we've already talked about all the reasons that the agency, why people don't file at the agency. This does go on to a rather different point, which is really a question where the people who even those who go to the agency level will mistrust the agency decision. I was originally going to suggest deleting the word mistrust, but I now think it's appropriate there in that context where they really think that the process wasn't fair. I think that's the sentiment, right, Chris?
Chris?
That's correct.
So I will move that, since I guess I'm a voting member, I can move that as an amendment. I hope it's a friendly amendment that just clarifies the sentence.
Sharon, is that a friendly amendment?
It is a friendly amendment. I'm happy to second it.
Is there any objection to the Duffy amendment reflected on the screen?
I have a question for John.
Okay, Ron Cass.
My question, John, is whether it would be better to say that their protest is denied instead of say that they lose.
That's fine with me. That I was trying to keep with the original language. I think it has to be, yeah, okay, do file and whose protests are denied. Okay, well, that seems fine.
Jack Bierman, you wish to be recognized on John Duffy's proposed amendment? Jack?
Related, very closely related. I think that the change
how related? Should I take a vote on Duffy's amendment, John Duffy's amendment?
Yeah, go ahead. I'm sorry.
Okay, is there any objection to the Duffy amendment as it appears on the screen? Without objection, the Duffy amendment is adopted, and now we'll turn back to Jack Bierman. Jack, please.
Yeah, I had a question about the use of the word follow-on in this paragraph. Is this confined only to protests that are on the same contract, or are we talking about both follow-on and subsequent protests? That is, people will stop going to the agency because of this problem, and then later protests, subsequent protests. That's my question is, what's the meaning of the word follow-on?
Let's turn to Chris Hukins. Chris?
Yeah, this particular comment, this particular discussion is focused on those who have filed at the agency and then would bring the follow-on. They're the ones the other class of potential protesters who never go to the agencies at all would be dealt with, wouldn't be captured by this.
Jack?
Is that problem captured elsewhere? That these issues generally these are the issues that generally discourage people from going to the agency?
Yeah, they are. In the enumeration, Jack, in the enumeration of problems, earlier in its first, second, third, fourth. That in my copy, it's pages 3 and 4. We talk about that general problem in the vendor community. There's a sense of mistrust. And just to be clear, to address John's point here, it's not only a question of being unfair to the vendors, but there's just a sense that because these are repeat players, and this is really a management tool for the agencies, if they can make agency level bid protests work correctly, they've mitigated a management risk. It's not only on the part of contractors a sense of unfairness, but just frustration with actions by the agency that don't seem sensible, because the agency is throwing a good management tool out the window just so that they could win an agency level bid protest.
Jeff Lovers, do you wish to be recognized on this issue?
Yes.
Jack has informed us in the chat that he is, quote, all set. So are you all set as well, or do you have a comment here?
I have a comment. I'm wondering if we still need to say will mistrust the agency's decision. I mean, can we just say whose protests are denied? Will file follow-on protests with GAO? They may just disagree with the agency's decision. It might not be a matter of mistrust. That seems like sort of a loaded word, and I don't think it's necessary.
Chris, do you have a response to Jeff, and then I'll turn to Aaron?
No, that makes perfect sense. That's fine.
Aaron?
Yeah, all else being equal, I probably would leave it as it is, but I'm going to defer to Chris on this one.
Is there a voting member who wishes to, John, did you wish to be recognized?
Yeah, I'd just say that I originally objected to the word bias early on, consistent with Alan Morrison's suggestion, but I thought the word here did convey something that they didn't trust the agency's process, and that made them more likely. And I thought that was Chris's explanation. And here I thought it did add something. I usually don't throw around the words bias, mistrust lightly, but here I thought it did convey a thought. So I would marginally be in favor. It seems to me that it conveys the sense of the report, but I won't object if some voting member moves.
Thank you, John. We'll recognize as the last commenter on this point, Don Elliott, and then Ron Cass, and that's it on this point.
I just wanted to say briefly that I support Jeff Lovers' point. I'm a little uncomfortable about speculating about the psychology of unsuccessful bid protesters. So if we can avoid getting into speculating about what's in their minds, I think that would be desirable.
Okay, Ron Cass is recognized.
All I'm going to say after Don's comment is me too. I agree that we're better off taking this out.
So the proposed amendment would read,
just as it is on the screen.
Okay, so it's correct on the screen?
Yes.
You wish to move that as an amendment, Ron?
I would be happy to.
Is there any objection to Ron Cass's amendment to strike the language on line 69? All right, without objection, the Cass amendment is adopted and that language is stricken. Again, before we return to the issue about the relationships among the three dispute resolution forums, are there any further amendments from the floor? I see no one who seeks recognition. We have about We're a little bit ahead of schedule here, which is fine and good. I think thank you, Mark, for putting that language on the screen. So we're talking about the language, the sentence that appears in line 15 through 17, and the Assembly has discussed putting in an additional sentence or two that would explain the relationship among these three forums. Chris, you, I suspect, are the best positioned to offer us draft language here, unless Aaron wishes to do so. You've carried a lot of water this morning. I'm wondering if you would prefer that we take a 5-minute break to allow you to compose some language, or would you rather just do it now on the fly? And the language needn't be perfect because the Committee on Style can clean it up after the plenary session. So I'll turn it over to you to see what your reaction is.
I threw a proposed sentence into the chat. That proposed sentence would go immediately after footnote call 7.
Okay, Mark, can we put that up on the screen? Oh, you can't see. Reeve, can you just read it out? Just read it out loud, please. Just and slowly, please, just so Mark can get it. Then we'll have it up on the screen and we can have a discussion of the sentence.
Vendors may bring protests in series. Thus, may, for example, protest first at the agency, then open paren, if unsuccessful at the agency, close paren, at GAL, and then open paren, if again unsuccessful, close paren, at the Court of Federal Claims.
Someone just pointed out to me on the chat that Reeve is not audible. He was speaking only to dictate Chris Eukins's language, which Mark has now picked up on the screen. So I don't think anybody's missed anything. I'd like to just turn to Ron Cass, because he, I believe, may have a suggestion on a suggested revision to Chris's language. Ron, I'll turn to you.
My suggestion was not a revision to Chris's language. It was to the sentence that precedes it, simply to reverse the order in which the places to protest are listed, because that way it fits then with Chris's thought that these may be done in sequence.
Okay, Aaron, as a committee chair, is Ron's amendment acceptable to you?
It is. I think it's fine either way. So it's fine.
All right, without objection, Ron Cass's amendment is adopted. Let's turn to Chris Eukins's language. And I don't think that we need to wordsmith this. I hope that the precise wording here could be left to the Committee on Style, which Aaron, who's an excellent drafter, chairs. But I would like to hear from any member who would like to respond to the language that's been put up on the screen. Jack Bierman, do you wish to be recognized on this point?
Yes, I just think that something ought to be added that says that, about the choice of which one to go to first. Vendors may bring initial protests in any of these three forums, something like that. I don't know. I don't want to try to do the language, but I think it's important to if we're trying to give the background here, to say that there's choice about which one to try first, and and then say they may bring them in series.
Chris, let me ask you for your response to Jack.
Sure, that sounds fine. So it would be another sentence right after footnote call 7?
Jack, what are you proposing?
Yeah, something like that. Vendors may choose. I feel I'm hesitant to do this because I don't know that if what I'm saying is accurate. But vendors may initiate their protests in one of the three forums, and may be able to bring protests in series. Because it depends on which one they start in, I would guess. I don't know though.
Let me turn back to Chris Hukins.
Yeah, that does make sense. There's a nuance here, which is that we were asked questions during the drafting process. Is it possible they could go in a different order? In theory, it might be, but it's very, very unlikely because each succeeding forum has more power in this realm. So maintaining this series, this ascending order is correct. But Jack's absolutely right that the vendor may decide just to go to one forum.
I'm going to recognize now Judge Susan Braden. She has a comment on this. Susan, please. Judge Braden, are you there?
Yes, can you hear me?
Yes, we can, please.
Yeah, I mean, I'm just concerned that people don't understand. I mean, you can't go back and forth between these. You can go to the GAO, and if you lose, you can come to the court. You cannot go to the court, lose, and then go to GAO. And there are a couple other things that I was trying to mention earlier when Jeff Lubbers raised an issue. First of all, you mentioned something about judicial review. I'm trying to look up my notes. The GAO decisions are not binding on anyone. They're not reviewed by any court anywhere at any time. They have no force of law. The Court of Federal Claims decisions, however, are subject to review by the Federal Circuit. So, the same thing is true for going back when the agency. There's not going to be any judicial review of the agency decision. So I just think there's some confusion about the process here that needed to be addressed. So as we're going back there, I think this needs to be flushed out in some, order that follows how the law works. I think it's confusing the way it's written right now.
I turn it back to Chris. Yeah, please, Aaron, please.
So my preference for all of this would be not to adopt the language that Chris has used. Instead, at footnote 7, do a cross-reference to the report where we discuss this in great detail, how all of this works. And an interested party, which candidly is already going to be pretty sophisticated about this stuff, is going to know what we're talking about. And if you really want to learn, then you just look at the report.
Who is trying to speak? Otherwise, I'll recognize Jeff. No, Jack, hold on one sec. Jeff was in the queue first. I'm going to recognize Jeff Lubbers first.
Oh, this may be superseded by Susan's and Aaron's comment, but I was just going to say any one of the three forums, when Jack said one of the three forums. But I hope we don't just sort of throw in the towel here. I mean, I think we're pretty close to having something that's more illuminating, and I wouldn't want to have to necessarily force people to go back to the report if they just want to read this recommendation.
Jack, do you wish to be recognized, Jack?
Yes. Well, I think that I was starting to try to. I was starting to try to draft substitute language after the or 3, the procuring agent, comma.
Jack, are you there? All right, we're going to turn to Dick Pierce.
I'm sorry. Somehow my microphone got muted again.
All right, Jack, you're recognized.
Okay, so my proposal, I'm not sure if you heard anything that I said. My proposal is to strike that new sentence and put a comma after, don't end that sentence, put a comma after the procuring agency and then the footnote 7, and then write, and depending on where the protest is initiated, may be able to bring protests in series, and then use the example that Jeff wrote as a separate sentence.
I'm going to recognize Dick Pierce now. Dick, please.
It occurs to me that this is, while I think this is very important, that I don't think it's susceptible to final resolution in the committee of the whole. Can we procedurally just delegate the process of coming up with a detailed description that is accurate to the Committee on Style, which fortunately is chaired by the right person, and assume that he would obtain the able assistance of Judge Braden and of Chris in getting it all right?
Do we have a sufficiently intelligible principle with which to work here? It was kind of a joke, but.
I think I understand this to the point where I suspect we're talking about 3 or 4 carefully crafted sentences. And I think that trio of people are in an excellent position to get it done. And I can't imagine how anyone would object to any joint product they came up with.
Ron Cass, thank you, Dick. That's very helpful. Ron Cass is recognized. And then I'll recognize Ann Joseph O'Connell. Ron?
Just before we kick this over to the Committee on Style, I think that where Jack has us is close to where we need to go. And if we then after the word series in Jack's sentence, skip over to thus, comma, for example, a protest may be filed first at the agency and then continue to the end of that sentence. I think we have pretty much what we're trying to say, and then we can leave the further resolution to the Committee on Style.
Thank you, Ron. I'm going to turn to Professor O'Connell. Ann?
Thank you. Can you hear me?
Yes, we can.
It might be worthwhile to refer to an amazing document that ACUS has already put out on background information here, the Information Interchange Bulletin number 7 on agency bid protests, which covers much of the information that we're trying to wordsmith on the fly.
Mark, you wrote that one, didn't you? Thanks for reading that, Ann. And thanks for making a plug for the interchange bulletins. We appreciate that. Does anyone wish to be heard further on the amendment to this paragraph that we're focusing on here? Aaron, are you willing to take on the Committee on Style task of working on this paragraph?
Sure.
Jack, did you wish to be recognized once more?
Yes, I would like to move the Bierman-Cass amendment subject to the Committee on Style's wordsmithing of it.
All right. So so is there any objection to the Bierman-Cass amendment, whatever exactly it is? Is there any objection to it? All right. Without objection, The Bierman-Cass amendment is adopted, and the Committee on Style will revise this paragraph consistent with the intent of the assembly. I know, Ron, you don't like the word intent, but I don't have a better one here. Anything else on this recommendation before we take a vote? I'll give everyone about, I don't know, 15 seconds, and then we'll take a vote, and then we'll proceed to the next item on the agenda. Okay, voting members, please unmute yourselves. All those in favor of adoption of the recommendation, please say yay.
Yay.
Hey.
Yay.
Opposed, nay. Okay, the yeas have it, and the recommendation is adopted with our sincere thanks to Aaron and especially Chris Eukins, who's gotten a little bit of a workout this morning. Thank you, Chris.
Thank you. I have to say thank you all very much. And having done this for 10 years, half in French, this is so much easier. Thank you all. Take care. Bye-bye.
Thank you. Thanks very much. We're not going to take a break. Okay, we're going to take a, can we, how long? Can we do that? You need 5 minutes? How long will it take to get a microphone on Reeve? Let's just stay live here and Reeve will get a microphone. Are we good to go?
Yes. How's it coming through? Can you hear me? Keep speaking. Testing. 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 Yeah. Oh, okay. Test. 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 Good.
And I'm still mic'd up to introduce Reeve now. And may I proceed? Thank you. We'll now hear from Reeve Bull, our research director on pending assembly projects, by which I mean those anticipated to result in proposed formal recommendations for the assembly's consideration, rather than the sorts of office of the chairman projects that I reviewed yesterday in my opening remarks. Before turning the floor over to Reeve, I'd like to thank our project advisory group, committee chairs and members for offering suggestions for new projects, and please keep them coming. With that, I'll turn it over to Reeve.
Excellent. Thanks, Matt. And thanks everyone for joining us today. So I will be brief. Mark, can we advance? So what you see before you is a selected list of pending assembly projects. If you want to get the full list, you can go to our website. I'll also mention one project that is likely to be teed up in the very near future. So there are 5 projects that I'll be discussing today. The first on the list is a study of early input on regulatory alternatives. So the idea of this—
Reeve, may I just interrupt you? We've got a few comments that Reeve is inaudible or is not. It caught up to him. Reeve, I apologize. I'll turn it back over to you.
Right. So excellent. So the first project that I'll be discussing is one on early public input on regulatory alternatives. So as you know, for many agencies, as part of the 12866 process, or as part of other requirements that they have in place, they'll actually consider a range of potential alternatives when undertaking a regulation, rulemaking. And ideally, the consideration of those alternatives would come relatively early in the process. Oftentimes when the agency actually gets to issuing an NPRM, it's already somewhat settled in terms of the approach that it wishes to take. So it's generally most valuable both to the agencies as well as to regulated parties that they get the input as early in the process as possible when their minds are still open as to what the optimal approach of taking would be. And in particular, public input can be especially valuable in those early stages of the process because regulated parties or beneficiaries of regulations or others might be able to identify new alternatives that the agency hasn't considered or perhaps react to alternatives that the agency has put on the table. And there are ways that the agency can go about doing this that it's relatively minimally burdensome. That the agency doesn't really have to proceduralize things, doesn't have to extensively formalize the process, but can informally reach out and gain input in a way that allows them to ensure that they're considering a wide range of possible alternatives. So our consultants on the study are Professor Stuart Shapiro at Rutgers Law School, as well as Chris Carrigan at George Washington University, both of whom have previously written on the subject, so they're very well positioned to do this study. The next project that I'll mention is a study of mass computer-generated and fraudulent comments. Let me define briefly sort of what we mean by that. So mass comments, the idea is that the agency not only gets a large number of comments, but it's much larger than what the agency would normally get. And then oftentimes there are specific groups that encourage their members to submit identical or nearly identical comments. Computer-generated comments are those that are written by some sort of algorithm, so an AI process, rather than being written by an actual human being. And then fraudulent comments could be either that somebody submitting a comment under a different name than what their actual name is, or they actually put fraudulent information in the comment itself. Now, there's obviously a fair amount of overlap between these three different types of comments. Oftentimes things are both mass comments and computer-generated, that's written by a bot. And the fraudulent comment issue also arises especially with computer-generated comments. But it's an issue that's really generating a lot of attention. The FDNS, now housed at GSA, has been very closely focused on this issue. Various bills have been introduced on the Hill to address this issue. So it's something that's generated a lot of interest, but there are a lot of tricky issues associated with it. Legal issues, like what specifically is the role of public input in the actual policy making, if it's not technical information, if it's more expressing views on the rule, and what, if anything, agencies can do to combat this issue, especially with respect to fraudulent comments. There are also a lot of practical issues associated with it, one of which, and one question we'll be addressing is this really a problem? Is it something that potentially overwhelms the agencies, or do they already have those steps in place to address the issue? So all of these issues will be analyzed as part of this project. And we have a very extensive research team that includes really probably the foremost experts working on this topic. So I'm actually myself part of the research team. In addition, we have several ACUS members, Mike Livermore, Emily Hammond, Michael Kurtz, and Bridget Dooling. And then we also have Stephen Bala and Beth Novak as part of the research team. And that one will be coming out in the next several months. The third project that I'd like to briefly discuss is a study of periodic and retrospective review. So as you know, we've issued several recommendations on retrospective review in the past, and these address things like how to triage the different regulations the agency has on board, what factors to consider while they're doing retrospective review. And then a separate recommendation we've issued on regulatory learning, how agencies can structure their regulations in a way that allows them to assess whether or not they're working well. One thing that has not been previously discussed in ACUS recommendations, and is part of the central part of this recommendation, is basically how to systematize the process. Several agencies have put in place a more extensive systematic process by which they periodically review their regulations on a specific schedule. In this project, we'll look at the potential benefits and costs of doing that. And if the agency does put in place sort of a periodic schedule whereby they review all rules or certain rules every X number of years, what types of rules should they look at? How should the process work? So this will look at basically various best practices associated with sort of periodic retrospective review. Our consultant is another ACUS member, Jonathan Weiner of Duke Law School, as well as colleague Lori Demir, also at Duke University. The fourth recommendation that we have listed here is one that's pending approval, and it's titled Procedural Fairness in Judicial Review. So you'll be hearing later today, Professor John Siegel has been hard at work, and Matt also mentioned this yesterday, on a source book of judicial review statutes where we comprehensively identify the statutory provisions providing for different aspects of judicial review. As part of that process, John has identified various drafting issues that come up in multiple different judicial review provisions. And where it would make sense for Congress to be attentive to these as part of basically sort of an overarching judicial review statute that would provide for different issues that have emerged, things like how they provide when, what begins the process of judicial review, or the number of days you have to seek judicial review. There are various procedural issues that have come up that could be basically addressed as part of some model judicial review statute. We held a committee meeting of the Judicial Review Committee. They took a look at the issues John has analyzed, offered some ideas on that, also had some additional ideas themselves. And they seem to think that it was a very useful and worthwhile topic. So this project will basically take up that charge and will be considered by our Judicial Review Committee in the spring, if approved as a project. The final thing that I want to mention, the final potential or ongoing project, is a study of virtual hearings and agency adjudication. By virtual hearings, I mean something different from video hearings, which is an issue, of course, we've already addressed in past ACUS recommendations. So the video hearing recommendation looked at basically when agencies have video hearing technology on site, they actually use. They have a facility where the hearing actually takes place. But especially during the COVID-19 era, virtual hearings, where it may be somebody's actual personal computer or some other device remote from the agency, where the hearing is actually being conducted. This is obviously relatively new. It's something that's obviously become much more prevalent in the COVID era. Our Deputy Research Director, Jeremy Grayvoice, has put in place a very helpful report looking at the frequency with which this happens. And, you know, it raises various legal issues associated with fair hearings and so forth, as well as a lot of practical issues. What are the best practices in terms of how the agency sets this up? Issues associated with that, and best practices that we hope to uncover as part of the study. And our consultant is somebody who you've seen before, Professor Fred Lederer of the William & Mary Law School, who works very extensively on these sorts of issues and is currently initiating his research on this topic. So that too will be a project that will be teed up for the spring. So that's it in terms of the selected projects. As I mentioned, if you'd like a more extensive list of projects, please go to our website. And of course, if you have any questions about any of these projects, I would be more than happy to answer them through email or other Thank you.
Thank you very much, Reeve. Mark, could you flip back? I just want to flip back to the slide Reeve had. I just want to emphasize that the fourth item on the list, the Procedural Fairness and Judicial Review Project, has not yet been initiated. And what was put before the Judicial Review Committee was some materials that John Siegel had prepared. And the purpose of the Judicial Review Committee was to solicit ideas for John's forthcoming source book, about which we'll hear more this afternoon from John himself. So with that, thank you very much, Reeve. We will now recess for lunch until 12:40. We'll resume, 12:45. We'll resume at 12:45, and we will consider the, I guess, the fifth project of the plenary session, which is public availability of information about agency adjudicators. Thank you very much, and we'll see you after lunch. They are Jennifer Alvarez, our program manager, whom many of you, I think, have already dealt with. She's done an outstanding job and done so under the difficult circumstances of having two small children on her lap. The second is Nathan Tomaso, our budget analyst, who has been critical to not only working on our budgetary and financial matters, but also all manner of administrative matters in the office. Thank you, Nathan. And then we have two new attorney advisors. One you'll hear from in a second, and that's Leanne Shriver. Leanne Shriver comes to us from Carrie Colonese at Penn Law School. And you may know Leanne, some of you may know Leanne from the regulatory review at Penn Law School, of which she was the editor-in-chief. And the second attorney advisor is Danielle Shulkin, who comes to us from our member and former vice chair, Sally Katzen. So welcome to all of them. I hope you have an opportunity to meet them when we return to normal. Our next recommendation is public availability of information about agency adjudicators. This one, like agency appellate systems yesterday, comes to us from the Committee on Adjudication. I'd like to thank the committee chair, Nadine Mancini, for chairing this the proceedings on this recommendation so ably, and also taking on two recommendations during the fall season. Thank you, Nadine. We're very appreciative of all the time you've given us over the last few months. The consultant on this, we have two consultants on this report. One is Kent Barnett, and the other is Leanne. Leanne prepared a report for this project, and Kent prepared a report on an earlier project that ACUS took up several years ago, a key section of which relates to the subject of information about agency adjudicators. So with that, I will first turn it over to Kent to hear his remarks about his report, and then we'll hear from Leanne about her report, and then we'll hear from Nadine Mancini on the course of the committee proceedings. Kent, please.
Sure, thanks, Matt, and I'll be brief. Just as a reminder for many people who I think were already part of the assembly, but if you weren't, I'll just give you a very brief background. In a 2018 ACUS report, Russell Wheeler and I presented our findings from a survey of agencies concerning their non-ALJ adjudicators and adjudications. Aside from obtaining updated data on the number of non-ALJs and their hearings, we obtained information on indicia of their impartiality, matters such as whether they had separation of functions, prohibitions on ex parte communications, performance appraisals, and the potential for salary bonuses. The key finding was the wide diversity of provisions that protect and do not protect these non-ALJs' impartiality. Moreover, matters related to adjudicator impartiality were found in numerous formats: statutes, substantive regulations, procedural regulations, internal documents, and even custom. This diversity of resources rendered it difficult to study and compare non-ALJs. In a later law review article, I proposed that agencies post one-page impartiality disclosures. And that disclosure would provide information for affected parties, Congress, agencies, and researchers. Today's recommendation, supported by Leanne's excellent report, makes a similar proposal, although broader in scope.
Thank you, Ken. And my thanks also to Russell Wheeler, whose name I should have mentioned, our public member, who was in fact indeed your co-author for the 2018 report, which, Ken, has been published, at least, or parts of it have been published could you tell us where it was published, actually?
Washington Law Review.
Okay. Thank you. That's very, very helpful. Now we'll turn to, excuse me, Leanne, to talk about her report, attached to which is part of Kent's article. Leanne?
Thanks, Matt. The report for this project built off Kent's great work, as he described, and was designed to discover what kinds of policies and information agencies currently make publicly available about their adjudicators, where those disclosures are located, and how they are made. In order to answer those questions, I searched the US Code, the Code of Federal Regulations, the Federal Register, other formal documents not found in the Code of Federal Regulations, and agency websites for information about a selection of agency adjudicators. The policies located through that research are in an appendix to the final report. That research revealed that agencies are already making a lot of information about adjudicators publicly available, particularly about who has the authority to review adjudicator decisions and the hiring of adjudicators, including their qualifications and appointment procedures. However, there is not much information available regarding compensation practices, including bonuses and performance incentives, or discipline and removal policies. There's also a wide variety of practices regarding how agencies disclose this information, as Kent said. But currently, agencies often rely on fairly hard to find documents full of technical terms, particularly for members of the public who would likely struggle to use the Code of Federal Regulations or dense agency case processing manuals. This research indicated that the most effective and transparent way for agencies to disclose information about their adjudicators is to create a short, plain language description about their adjudicators on their websites that includes the basic information about policies governing them, and then link to all the places where the information is already located in more formal documents for people who are looking for more in-depth information. I'll hand it back to Matt.
Thank you, Leanne. Thank you, Ken. We'll now take up the manager's amendment. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. Are there any members who wish to be recognized for general discussion? Jeff, do you seek recognition?
Yes, briefly.
Briefly.
Yeah, I'm a member of the committee. I strongly support the recommendation. I did submit some pre-submitted amendments, and that for some reason on this recommendation didn't get reflected onto the red line. So I have a few minor suggestions on word changes and a couple of suggested deletions. I hope I can be recognized at some point to suggest those.
Reeve, are they not reflected on the red line? Jeff, Reeve tells me that they were addressed in the manager's amendment. Any comments that you have that are not reflected in the red line, as Lover's comments, are reflected in the manager's amendment? So take a look at the.
I will.
Go ahead.
I will take a look at it, but I didn't see them in some of them in there. So
I apologize, Matt. I'm not sure we got those.
Well,
but at any rate, it's not a big deal. It's just give me a chance to suggest them at the appropriate time.
Okay, thank you. Anyone else does anyone else have any general comments on the recommendation before we proceed to the amendments, the pre-submitted amendments? All right, we'll turn first to the council amendment. The council has a single amendment to one of the appendices. Is there a member of the council who wishes to speak to this amendment? I think it's relatively self.
Matt, I'm happy to if you want me to.
Okay. Cass is recognized.
Yeah, this amendment is designed just to revise the wording a little bit to track more carefully and more precisely the wording of the statute. Other than that, I don't think it makes any substantive change.
I don't have any concerns about the amendment.
Okay. Objection to the amendment from the first council, the only council amendment. Okay, without objection, the council amendment is adopted. Our first pre-submitted amendment or comment comes from our senior fellow, Ron Levin. It relates to the title, and I'll now recognize Ron. Ron?
Yes, thank you. When I read the title of it as it now reads, which is public availability information about agency adjudicators, it led me to expect that what I was going to read about in the draft recommendation would be information about the identities of the adjudicators themselves, you know, their names and their bios and where they went to school and what their hobbies are and so forth. And I did not think that was the purpose of it, and I didn't think that is something we should be addressing. So I had a few exchanges with the staff about possible clarifications. They wanted something concise. And so what we came up with is what you see in the red line, which is publication of policies governing agency adjudicators. So that would be what I would espouse, but I can't move it. If someone else would move it, I would be pleased.
Change. Let me start with Nadine Mancini, the committee chair.
I don't have any problem with that. I didn't read it that way, but I could see how someone could now that you've pointed it out. So I think the proposal is fine.
Ron Cass is recognized.
Yes, I'll move the adoption of the change proposed by Ron.
See on the screen that I see in the chat that John Duffy supports the title change. Is there any objection to the title change reflected on the screen? Without objection, the title is changed. Now we'll move to our second pre-submitted comment, and that comes from Dick Pierce, and I'll recognize Dick Pierce now. Dick?
Thanks, Matt. So my concern is that, as some people know, there are dozens of cases literally pending involving the status of agency adjudicators, really basic questions about who can appoint them and who can't, and whether they have any degree of decisional independence or whether they're even subject to the normal limits on removal power that apply to other civil servants. So my question is, did the committee talk about whether to include some reference to the fragility, shall we say, of all of this, the pending litigation that could cause each aspect of this description to be inaccurate sometime during this term of the Supreme Court, the Federal Circuit, or the DC Circuit?
May I ask, Jack Bierman is telling me that my mic is not picking up well. Nadine, can you hear me okay?
I can hear you, but it's a bit fuzzy and scratchy.
Okay, let's pause a second here. Are we picking up interference on his mic? Pardon? It might be a new tower. It is a new tower. Can you hear me better now, Nadine?
No, but I can hear you enough to know you're talking to me.
All right, well, then we have to take a break here and get the microphones right. We'll take a 1 minute break.
Okay.
That was fine. Did you say that was better just now when you started talking again?
It
Sounded like you
sounds
were saying,
it sounds a
okay,
little better. It's still.
just one person.
Nadine, can you hear me better now?
I can hear you, but there's still some background noises, almost like a scratchy record or something like that. But I can hear you and I can respond to the extent that.
Well, hold on a second, because there's a bunch of comments on the chat about the audio here. So let's see if we can't get this right. If we can't get it right, we'll just move on.
I think somebody got it right.
Is it better now?
Much.
Okay, thank you. And thank you, Tim. Nadine, can you respond to Dick, please?
I can.
Yes.
So the short answer is that the committee did not consider that. The recommendation is focused on established current policies and practices of an agency. So to the extent that there's pending litigation about unresolved issues, which of course there are, as you rightly point out, the agency would be hopefully tracking that and adjusting their policies and practices once that litigation is concluded. I think the focus here of the project was largely on disclosing information that's current and accurate. And to the extent that there may be questions down the road that courts have yet to resolve, I don't think that's quite within the scope of the project. But I can, and Leanne can speak to that as well.
Kent, do you have any thoughts on it, or should I go back to Dick?
Yeah, I can speak just quickly. Sorry, I'm having trouble unmuting. The other concern I had with it was a little more with how the last question is phrased in the note or on the side about, did the committee consider recommending that agencies include a reference to any pending cases? And I wouldn't be likely to support that, because I think that creates too much dynamism in the project for the agencies, where they're going to have to constantly be on top of which cases are pending and what the status is. And I think that can get even more problematic, aside from whatever we think of the cases that are being litigated now. If you have a series of frivolous litigation that's being put forward, I don't want to create too much of a burden for the agencies in maintaining this website space where they provide information on the adjudicators.
Can I add one more point, Matt?
Please, Nadine.
The only other, I agree with Kent. It would be burdensome, and I think kind of outside the scope of what this project was intended to accomplish. The only other thing I'll mention is that obviously if the committee was looking at disclosure of decisions, adjudicatory decisions, which I think we have another recommendation about. An adjudicative agency is providing that information on their website arguably already. And so to the extent that those issues are raised in litigation before the agency first, before they go to a court, that information is there. It's not flagged as a reference, but the information is there already.
Dick, anything further on this?
Yeah, I mean, I continue to have concerns about whether how useful this information will be to the parties, interested members of the public, and the bar, most of whom don't follow the Supreme Court's Article 2 campaign. And there are right now thousands of adjudicators whose basic status is in grave doubt. The Supreme Court has one case before it this term that raises the question of retroactivity and how far back you reach when you conclude that an adjudicator's status was unconstitutional. And it could well be that this information that purports to be an accurate description of today's law will turn out in retrospect to be an inaccurate description of today's law, depending on the outcome of the Social Security case that's before the court now. And of course, in Arthrex, you've got before the court the question of whether the process for appointing the several hundred administrative patent judges is unconstitutional, and whether even the basic minimal safeguards against removal and safeguards of decisional independence that apply to all civil servants have any application to the APJ judges. And I know that there are lots and lots of people sitting on the sidelines of those cases preparing their filings as follow-ups with respect to agency adjudicators all across the government. So I'm not sure that this information is going to turn out to be accurate and useful to the general public, the parties, or their lawyers.
Thank you, Dick. I recognize Alan Morrison, and then we'll turn to Ron Cass.
Oh, I agree with Dick that the pendency of these litigations is important and ought to be noted. I'm not sure that I think it ought to change the nature of the recommendation, but I do think that we ought to have something in the preamble that the conference at least recognizes the pendency of these cases, and that the some of the details of these recommendations may have to be revisited depending on the outcome of the cases. And I don't think we need to say any more than that. I leave to the Committee on Style how it would be put. But I think that that would be an important thing to note in the preamble, so it looks like at least the conference is aware of these cases. The patent judge cases before the court on the merits, including retroactivity and remedy. The Social Security cases is before the court on the question of whether the claimants in those cases had to raise the issue before the ALJ or whether it was forfeited. The merits issue was not before the court, but it'll certainly be back before the court. In addition, the Biden administration may not go along with what the Supreme Court said, I'm sorry, what the Solicitor General and the President said following the decision in Lucia. So for all those reasons, there's a lot at stake here, and I think we would be remiss in not at least recognizing the pendency of these cases. Thank you.
Right. There are a number of other people, members who wish to be recognized. I'm going to start with Ron Cass.
I'm going to take a partially concurring position here. I agree with Dick and Alan that so much is in play right now that we ought to have a note in the preamble saying we recognize that the cases in court and a number of different developments may change the information contained in the report. But I think we should also note that the basic thrust of the report for agencies putting up on their websites information about their adjudicators and the policies and regulations that involve their adjudicators is something that the conference believes will be appropriate going forward, no matter what changes are made in the law.
Let me turn now to, thank you, Ron. Let me now turn to Tristan Levitt, a government member and the General Counsel of the Merit Systems Protection Board.
So just
Tristan.
two related, sorry, thank you. Two related thoughts. One, in general, one way to maybe take this actually is to, in noting, I'm not opposed to noting generally the litigation if you don't reference specific cases, but just note that under the appointments clause, you know, a recent reexamination of that in the Supreme Court has led to a number of different cases and challenges. You can arguably take that and you know, recommend or strengthen the need for this by just noting that because of those challenges when we talk about how appointments were made, the legal authority, the other things related to that. Putting that in the intro may help to, again, strengthen the case for the rest of the report. That said, the only trade-off here is obviously some agencies where that may be in question may be reluctant to follow these. But again, I think generally, and in the interest of this standing the test of time, just noting that and then noting that that's a stronger, you know, that adds to the need for these recommendations would be useful.
Thank you, Tristan. We'll turn now to John Duffy. John?
Yes, I very much agree that at the very least, there needs to be an encouragement to agencies to put a caveat on their websites if they're going to include this information, possibly also a cross-reference to if they have an agency litigation website where at least their own litigation concerning the appointment of their judges can be placed. Obviously, as Dick points out, sometimes there's going to be like the Supreme Court case, and the administrative patent judges can have effects on other agencies, but at least give some sort of caveat. The language that Dick points to also has, I think, another troubling aspect, which I don't know whether it's a separate issue or not. I will just raise it very quickly. The language at the beginning of the recommendation that is highlighted in pink, it talks about applicable policies and practices. And I don't know why it doesn't say applicable statutes, regulations, policies, and practices, because I know from being involved in at least the administrative patent judge's case that the agency will say something like, these judges have tenure. And then you go to their briefs and there's like no authority for that. They never trace down the statutes and regulations or the OPM regulations. And so I think that encouraging agencies to not just say what their policy is, but actually track down their legal authority would be best to encourage them. And I don't know why the language uses this general phrase rather than more specific encouragement of legal authority. That may be a separate issue. I'll close there. Thank you.
We'll make sure we return to you if that, and remind me, John, if it does not, if I neglect to do so. Emily Bremer is recognized next. Emily.
Thank you. I agree that the ongoing litigation should be mentioned, but I would suggest that we not include language that says sort of vaguely and overarchingly that the recommendations may be invalid depending on how that litigation comes out and may have to be revisited, because that seems to me that no matter how the cases are decided, that will ensure there will be uncertainty as to whether and to what extent the recommendation remains valid. I think we can leave that part unspoken, and ACUS can keep an eye on developments and revisit the recommendation if necessary without sort of solidifying that possible invalidity in the text of the recommendation.
Thank you, Emily. Jeff, did you wish to be recognized? I don't know if I neglected you.
Yes, I do. I agree with Emily 100%. And I also think that it's worth putting something in the preamble. But what Dick seemed to be suggesting was that the agencies should kind of put up a clearinghouse of cases involving agency adjudicators. And I wouldn't want to put that burden on the agencies. I think that's something that a law school could do, or Judge Manual's association could do, or the ABA's notice and comment blog could do. But you know, and it may be a good idea, but I think just a cautionary statement in the preamble would suffice.
Thank you, Jeff. Alex Manuel, did you have a comment?
Yes, I just wanted to comment very briefly that I just is going through the material. I agree with all the comments that have been made that there should be, at least from the standpoint of administrative adjudicators, Dick raises huge issues and points that we're all struggling with and trying to come up with ideas about it. And as you know, Matt, and many others here as well, we've we're presently in the process of developing sort of a federal central panel concept, and there are of course many approaches to the issues that are facing federal adjudicators. But I agree that I don't know that it needs to be dealt with extensively in this recommendation. And I just note that in footnote 4 that there is a reference to Lucia and Arthrex. And so perhaps the drafters could just focus on sort of expanding that language in a way where there doesn't have to be a major section redrafted here.
Thank you. I just want to clarify something before I get a whole lot of emails. I think you said we are working on a central panel concept. Maybe I misunderstood you. ACUS is not working on a central panel proposal. So I just want to be clear on that point. And that's without any commentary on the merits of that proposal.
Absolutely, man. I don't want to misstate, but I just wanted to say I was speaking of InCouch, the of the ABA. I apologize.
Okay, thank you. Kristen Hickman is recognized.
So are you, I agree with Judge Manuel that footnote 4 would be a great place to put a statement. Are you looking for draft language or are you planning to send it to the committee on style?
No, Kristen, we would love draft language from you of all people.
Well, I don't know that this is going to be any good, but I'm happy to propose something that could go after the citations that are currently there. You know, and I don't know whether this is just to get discussion started on this. I don't have any real ownership over this language, but cobbling from what Dick had in his comment bubble earlier, how about something, the administrative conference acknowledges ongoing litigation regarding the constitutional status of many agency adjudicators and the continuing validity of the means and circumstances of their appointment and removal. Period. I mean, I don't know that we necessarily need to say any more than that. Because I don't think we have any sense of what the implications of any of that litigation will be for this recommendation. It's just simply an acknowledgement that, you know, that the litigation's ongoing and we're not stupid. We're aware of it.
Okay.
And I'll leave it at that.
Thank you, Kristen. I very much appreciate your proposing specific language. That's very helpful. It gives us something, gives the Assembly something to work with. Let me turn to Jack Bierman, then Ron Cass, and then Alan Morrison. Jack, if your comment is on this particular issue.
Yes, it is. I think that the material that Judge Manuel pointed out in the preamble with the text and the footnote at footnote 4 actually largely takes care of the problem that Dick Pierce mentioned. And, you know, the only question I would have would be, would it be helpful to put up to date in that sentence that that Dick flagged, so that it's clear that we're telling agencies, you know, to keep an eye on the Supreme Court's docket also. But otherwise, I actually think that Dick's problem is taken care of by the existing language in the preamble.
Ron Cass?
You know, I like what both what Jack just recommended and Kristen's language, although I do think that the language actually, or something like that, belongs in the text and not just in the footnote, because we are just simply flagging that there's a lot of ongoing litigation. We're not saying what's happening with it, but I think it is prominent enough, whatever happens with it, to recognize it in the text of the preamble rather than in the footnote.
I believe that thank you, Ron. I believe that Alan Morrison has a comment on the placement of this text. Alan?
I concur with Ron. Too important to be left a footnote. The text is not sufficiently clear at that point unless you know what you're looking for.
Let me turn back to Kristen and ask about her thoughts on the placement of the sentence that she proposed. Kristen?
I have no problem putting it above the text. I was just trying to figure out whether it would go where that footnote 4 is or somewhere else in the text. So if you'll circle back to me in just a minute, I may be able to offer a place where it would go.
Okay, let's turn back to John Duffy, because I think that maybe your forthcoming proposed amendment is unrelated to this point. It can be addressed separately. Can we turn back to you, John, to line, well, it's line 61 on the red line in the packets. I don't know if that's been changed. Yes, it's still line 61. John, I recognize John Duffy once more. Could you just revisit this issue for us, John, and then we can see if we can't reach some resolution?
Sure. I would suggest putting in between the words generally applicable, or after the words generally applicable, I would put statutes, comma, regulations, comma, and that's all. And I note that that's consistent with paragraph 2 in the recommendation, which does talk about putting the hyperlinks to specific statutes and regulations, which I think is a good idea. And if not, citations. But it seems consistent to have those in the basic recommendations. So that's my proposal. Thank you.
Thank you, John. Nadine, may I just look to you as the committee chair to see if you have any reaction to John Duffy's proposal?
My reaction was going to be that we cover that in paragraph 2, and John pointed that out. It was discussed by the committee and decided to make it a separate point. I guess I don't think it hurts to state it first in the first paragraph and then revisit it in the second and flesh that out a little more.
John, anything further?
No, I do think, I know it is in the second paragraph with hyperlinks, but I just think it is better to say that we really want legal authority in the very first, right at the top, because I think agencies sometimes might say they have a policy and not really have grounded it well in legal authority. And I know that happens, has happened with the PTO, the Patent and Trademark Office, with the administrative patent judges, that they're not actually too sure legally why they think the judges have tenure. That's their position that they have tenure, but they really don't. They haven't traced out the legal authority very well.
Let's go back. Can we put John's amendment on the screen? Does anybody else wish to be heard on John's amendment?
Matt, I have a quick question for John.
Please, Ron.
John, if you're concerned about the way that agencies portray their legal authority, are we better off having them do descriptions of it, which is what we say in paragraph 1, or to have them simply provide the links to it, which is what we say, I think, in paragraph 2? And, you know, I'm agnostic on what the right answer is here, but I think there may be a tension between asking them to describe it if we're concerned about their the accuracy of their description.
I'm not concerned. Oh, can I be recognized?
Please.
I'm not concerned that their accuracy of their description. I'm kind of just concerned about their sort of vagueness of their description. They'll say, you know, our judges have tenure, and that's a description, and that is their position, but they just haven't listed the authorities under which they think that's true. And you know, I think 2 is, you know, the agency might think that you could say, well, if we didn't, you know, put a link to if we didn't cite some statute or regulation, then paragraph 2, they might think is, well, you know, that says to put links in there, but we don't have any statutes. This is just our policy. And I just think it would be better to put to remind them that they really have to ground their description in legal authority. So that's my proposal. It's not the end of the world if it's rejected, but I think it's helpful.
Nadine?
I think it's fine. I hear what Ron Cass is saying in terms of the idea of this recommendation, this paragraph, is to describe it. I wonder if the idea might be better served by saying generally applicable policies and practices, including the statutes and regulations underpinning them, or something to that. That's kind of inelegant, but that sounds to me like more what John's getting at is grounding the policies and practices that are being described in the legal authority that allows it.
John, what do you think of Nadine's proposal?
I mean, I think, I don't know the specific language. Maybe you could use that, leave that to the committee on style. But I think definitely putting statutes, regulations, policies, and practices seems like a perfectly reasonable way to put it in. I don't know the alternative seems, I mean, just drafting wise might be hard. I mean, we say that the descriptions have to be short and straightforward, but there's a lot of information then. There's, you know, what, more than 10 paragraphs, 11 paragraphs of things they have to cover in these short descriptions. So I think putting the legal authority in there is consistent with the level of detail that we have them trying to scope out in these descriptions.
Nadine, do you want to take a stab at, or can we try to take a stab at getting up on the screen what you suggested? I think that may do it, even if it's inelegant at this point.
I think it was all generally applicable policies and practices, comma, including. We could say simply the legal authority, or if we wanted to use John's language, I think he was specific about statutes.
Matt, can I offer one amendment?
Yes, Ron.
I think I just muted myself.
No, we can hear you, Ron.
Okay. Instead of including, could we put along with? Because we don't want to make it sound as if the policies and practices include the statutes.
That strikes me as a good idea.
Yes.
Ron and Nadine, do you like that?
I do.
Let me turn back to John Duffy. John?
This is fine. You know, again, you might want to leave it to the Committee on Style, but that's fine. Yeah, I definitely think that the legal authority should be cited.
And
that's
go ahead. I'm sorry, John, please.
Oh, that's consistent with paragraph 2, but I think it's so important that it should be right up front, and it also eliminates that ambiguity that paragraph 2 could be viewed as saying to agencies, well, you know, provide hyperlinks to your legal authority, and they look back at what they've written and they say, well, we didn't cite anything, so we don't have to provide any hyperlinks.
Nadine,
Yeah.
Do you support John's amendment, if I may put you on the spot?
Yes, I think it's fine, although I think if I understood Ron's amendment, it was to replace including with along with, or maybe
Correct.
I misunderstood. Okay.
No, including should not be in there.
Right. Okay. I think it's fine.
All right, is there any objection to the Duffy amendment as it appears on the screen, subject to revision by the Committee on Style? All right, without objection, the Duffy amendment is adopted. I see some chatter about Oxford commas. We do always use the Oxford commas in recommendations, and the Committee on Style will ensure that the Oxford commas are used throughout all of the recommendations where appropriate. Let me turn back to Kristen on her amendment relating to footnote 4. Kristen, you're recognized.
Thank you, Matt. You know, so actually, as I've looked through this, I think the place that we would want to put the text that I proposed in footnote 4, if you want to move it up above the line, I think you just move it to the end of that paragraph. So it'd be line 10. And I think it fits okay there. Again, I'm happy to, you know, I welcome any adjustments as to the language, since this was something that I just came up with on the fly.
And you did well. May I, let me ask if there are any members who would like to be recognized with respect to Kristen's language, both its content and placement. Nina Mendelson has a comment. Nina, please.
Yeah, hi. Very minor comment. And the document's very small on my screen, so give me a second. I would suggest adding the word over before the continuing validity, just to be clear that that is also a subject of ongoing litigation. No, the litigation is over the continuing validity of the means and circumstances. Is that what you intended, Kristen?
Kristen?
The only problem with that is because, so that wouldn't say that it's, the administrative conference acknowledges ongoing litigation regarding the constitutional status of many agency adjudicators and over the continuing validity of the means. You know, I don't know that over does anything except kind of make it confusing, because regarding would apply to both the constitutional status and the continuing validity. So I don't understand what over adds.
Yeah, you're right. I retract that. I retract that.
It's hard with the words being small on the screen. I totally get it. The only reason I can read it is I have a ginormous screen in my office.
Any other members wish to be recognized on Kristen's amendment? All right, we have the amendment up on the screen on lines 10 through 12. Is there any objection to the Hickman amendment? All right, without objection, the Hickman amendment is adopted and the recommendation will be revised as it appears on the screen on lines 10 through 12. We'll turn now to Alan Morrison, who has a proposed amendment to paragraph 2 of the recommendation. Alan, you're recognized.
Thank you, Matt. This is a very simple addition, and that is requiring a position description. It turns out in many of these litigations, there isn't a position description any place in the litigation at all. And that seems to me to be a rather fundamental flaw in the litigation, but at least we can't do anything about that, but we can cure it in the recommendation. And in fact, when you actually look at these position descriptions, they come out to be quite interesting and revealing as to what the agency really thinks that these adjudicators are doing and not doing, and what their relation is to the other parts of the agency, which is particularly revealing because they're candidly done when they're not trying to reach a particular result in litigation. So I think they're very valuable, and it's a matter that the public ought to know about. So I understood that this was not controversial, but perhaps I'm wrong.
Well, that's for the others to say, not me. Let's ask Nadine if what her position is on what Alan has proposed by way of adding position descriptions. Nadine?
I don't have a strong feeling about it one way or the other. I don't think it hurts to include it. I was trying to look to see if it had been mentioned in either of the templates in the appendices, and Kent or Leanne might recall that better than I do.
Kent, do you have anything to say on this subject?
I don't recall if it specifically mentions it, but I have no objection to it at all.
Leanne, do you have any thoughts on this?
I'm pretty sure that the appendix does not currently mention position descriptions specifically.
Okay, is there a voting member who wishes to move for the inclusion of position descriptions? Because Alan is a senior fellow and can't move an amendment.
I'm happy to do it.
Ron Cass moves Alan's amendment to add position descriptions on line 92. Any objection? Excuse me. Robert Gerard would like to be recognized. Rob, let's turn to you, and this is definitely within your wheelhouse at OPM.
Yeah, I'd just like to say that I don't think that that's necessarily going to be particularly useful. Position descriptions in the federal sector are often a matter of classifiers in the HR office grading a position to determine what level of the general schedule it should be, whether it's a sedentary position, that sort of thing. I think that generally speaking, position descriptions would not be particularly useful to claimants or litigants before an agency.
Alan, did you have something further on this point?
Yes. As a litigant in a case which I'm about to file a brief in the Supreme Court, and I found the position description to be incredibly useful and said many things that were not said elsewhere. And so I don't know about people. People applying for the jobs, this is what they see all the time. As far as other litigants are concerned in other kind of cases, I don't know. But certainly those involving the appointments clause, this is extremely useful. Indeed, I would say highly relevant information, regardless of what other uses it may have for it. Matt, I have two other small matters when we get done with this that somehow.
Okay. Anything further on this point? Does anybody else wish to be recognized on this point? That is the inclusion of position descriptions. Ron, you would like to move that as an amendment?
Sure. Alan and I always agree.
Okay. Always. Is there objection to the Morrison amendment on line 92, excuse me?
I'd object to it.
Okay, so we're going to have to take a voice vote on this. Could you please turn on, unmute yourselves? All those in favor of the Morrison amendment, please say yay.
Yay.
Yay. Yay.
Yay. All opposed, nay.
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 Sorry, the yeas have it and the Morrison amendment carries, is adopted. Line 92 will be amended to add position descriptions. Before we get to, Reeve, I think that was the last pre-submitted amendment. So Alan, we will turn back to you.
I had a question which I submitted on what is now lines, the paragraph above, I guess it's the end of one. It's lines 82 and 83, the last part. Agencies may choose not to provide access to policies covered by a Freedom of Information Act exemption, that's fine, or may be required not to disclose information otherwise protected by law. I simply didn't understand what that last phrase meant. And I just didn't understand what it meant. And so maybe somebody can explain it to me, please.
I turn to Nadine on this. Nadine?
Yeah, I am not recalling discussion of this, and it may be just that after 4 meetings, it's all blurring together to me.
I would agree. This is mush. I would agree with Alan. Is there a committee member who recalls why this language is included, what the intention was, and if there is an intention, maybe we could come up with better language? Leanne, do you have, I'll put you on the spot for a second here. Leanne, do you have any thoughts here?
My recollection was that this was about the Privacy Act, and we were worried about some other laws that govern when agencies may disclose information.
That sounds right to me.
I can't remember if it was just the Privacy Act or if there was a second law as well.
Is there a proposed? Is that Alan seeking recognition?
Yes.
Alan, please.
I believe the Privacy Act is an exemption 3 statute. And if it requires that information not be disclosed to be picked up under the first part of that sentence.
So Alan, would you propose striking everything after the word exemption and putting a period after exemption?
I would.
Does anybody wish to move? Is there a voting member who wishes to move that as an amendment?
Sure.
Ron Cass moves it as moves that as an amendment. Is there objection to the Cass amendment? Without objection, the Cass amendment is adopted and the language on this reflected on the screen is stricken. Jeff Lubbers, did you wish to be recognized?
I was just going to suggest to say to withhold rather than not to not disclose, but that's
All
moot.
right, so that's moot. So what else?
Do you want my other two quick comments now?
Well, are they committee on style matters, or are they things that the assembly should take up?
Well, I mean, I think they're committee on style matters.
How long will, let's do it right now. Let's get
Okay.
this done.
If you go to lines 16 and 20, we use the term addresses. Well, now it's actually 19 and 20, 21. We use the term addresses twice there. And my concern is that it's a little misleading in that the recommendation is really addressed to the agencies that employ the adjudicators, not to the adjudicators themselves. So I was going to suggest saying, use the word pertains to in the first addresses and maybe covers in the second addresses.
Nadine, may I turn to you as the committee chair?
Fine. It's fine.
Is there any objection to what I'll call the Mancini amendment on lines 19 and 22? All right, without objection, adopted.
Next one's on like 38, probably. It's 35 originally. Where it says resides, oh, it's 37. They reside in the APA. These maps reside in the APA. I thought that was kind of a funny way of saying it. So I was just going to say are stipulated by the APA OPM rules because they are stipulated by. That's it.
Nadine, is stipulated awkward?
I mean, reside in seems like a funny way to describe it.
Stipulated doesn't sit real well with me, but let me turn to Nadine.
Because they are found in the APA?
All right, that's better than reside in.
All right, we'll leave that to the committee on style. Let's just put a note on there, committee on style. Jeff, did you have anything else?
I had a couple of proposed deletions, but those would be more substantive.
Okay, well, let's go through them. Where are they?
Okay, one of them, they're in the appendix. One is line 156, where we reference the executive, well, it's actually now line 157, where we reference EO 13843. I was just going to suggest that because I think it's likely that executive order might be revoked. So that's one. I mean, that's just.
Does anybody wish to move an amendment? All right,
Okay, next one is, my next one's more dramatic. It's to go to the last appendix, which has all those examples, sort of Photoshop examples of agency websites. And I would recommend not including those in the recommendation. And let me just say a few words about it. So since I've been associated with ACUS since 1975, I think it's quite rare that ACUS publishes this kind of photocopied appendix. Our recommendations are already beginning to get longer and longer, and this particular appendix, in my view, unnecessarily extends the length by 5 pages. And these examples will probably be out of date at some point fairly soon. It also costs $453 per page to publish in the Federal Register. And
let me stop you there, Jeff. This particular appendix would not be published in the Federal Register. It would just appear on our website. So let's put the cost aside here. I'll worry about the cost.
Okay, so my proposal is that we just put these in the report and then put a reference to the report pages in the recommendation. So I think that would be better than having all this.
Well, the report is done already, so let's talk about the recommendation.
Well, then I would propose deleting this appendix and putting maybe if you want to put citations to the websites, fine. I just think it's unnecessarily cluttering up the recommendation.
Let me turn to Nadine, because I think the inclusion of these appendices were heavily discussed by the committee, of which Jeff is a member. So let me turn to Nadine, and then I'll come back to Jeff if need be.
Thanks, Matt. My recollection is that these are helpful examples for agencies. I can't speak for other agencies, but I think it's unlikely that they're going to dive into the report in great detail, but they may look at the recommendation. And I think it would be helpful for an agency to see that other agencies are doing this and doing it with ease. It's not a difficult task to do. There are several examples that give them options for how to do it. So I think there's value in including it. The logistics of whether it's published or not published or how it's made available is a different matter, but I do think there's value in including it.
Is there a amendment to overrule the committee on the inclusion of the appendices, this appendix? Or is it, what are you proposing exactly, Jeff?
Well, I think I should probably give up the ghost here, but especially since you're not going to publish it in the Federal Register. So if you've made that decision, I'll withdraw my suggestion.
Okay, so what else did you have, Jeff?
That's it.
Okay, thank you, Jeff. I'm going to turn to Robert Gerard, who seeks recognition, I think, on a matter relating to the appendix.
Sure. I don't want to jump ahead of things if we're not proposing.
No, we're there. You're ready. Go ahead.
Okay, sure. For Appendix A, I had a proposed amendment for lines 119 to 21, the description of how ALJs are paid.
Do you have that up, Gavin?
I see it on the middle of 119 down to 122.
Okay.
So as an explanation, OPM does not prescribe the pay rates for ALJs. It's a statutory pay system, and no federal employee receives a cost of living adjustment. They get general annual pay increases and locality pay. I'd propose keeping ALJs are paid according to the pay scale for ALJs with link to the scale and bracket as it currently is there, and then delete the rest of the sentence and replace with set by statute under 5 USC 5372, subject to annual pay adjustments.
Is that on the screen as you'd like it? Maybe a comma there, but otherwise, is that on the screen as you'd like it to be phrased?
Yes.
Rob? Nadine, do you have any objection or concerns with Rob's proposed amendment?
I don't. Thank you, Rob.
Welcome.
Is there any objection to Rob's amendment? Okay, without objection, Rob's amendment is adopted. Are there additional, well, I think Alan Morrison may have wanted to be recognized a few minutes ago. Alan, do you seek recognition?
I do.
Okay, please, you go ahead.
This is in line 102 of the recommendation. I think it's line 102 of the recommendation. Let me see. No, it's in line 103 now. I find it never to be appropriate to use the word merely and would like to see it taken out. Merely announces a conclusion. It doesn't tell you how you get there.
Okay, the Committee on Style will review that.
That's all.
Anything else, Alan?
No, thank you, sir.
Robert Gerard seeks recognition for an unrelated amendment. Rob?
Yes, this is actually an amendment to the other appendix on the non-ALJ adjudicators with respect to their pay.
Okay, hold on one sec. Let's get that up.
So that's line 173.
Okay.
Well, actually, I think that's changed.
170,
changed.
171, 172.
Okay, the same point. We do not set the pay of agency adjudicators. In addition, other than ALJs, I'm not aware of any employees who are not eligible to receive performance incentives. So I'd recommend simplifying that. I think that the first part of it is fine. Adjudicator title are paid according to the pay scale for adjudicator with link to the scale. I'd stop there and delete the rest of the sentence and propose some replacement text. And then after the closing bracket, I'd put a slash and then put a new open bracket and write discretion of the agency head, close bracket, period. So what I'm getting at there is there are many adjudicators who are in a identifiable pay scale. They're in the general schedule, the senior executive service, or an alternative pay system. And we can certainly have an agency put a link to that pay scale there. There are others, such as certain administrative patent judges, Indian probate judges, perhaps others, whose pay is administratively determined at the discretion of the agency head. So that's a second category. So that would provide a placeholder for the agency to put in either the applicable pay scale or that it's set at the discretion of the agency head.
So how would you like this to read on the screen?
I think that it's there the way I'd like to see it.
Okay. Nadine, may I turn to you for reactions?
Yeah, I don't have any concerns with it. Again, thank you, Rob. I learn something new every time we do one of these things. I was unaware. Interesting.
Thank you, Rob. That's very helpful. Is there any objection to this amendment on lines 171 through 3?
Matt?
Yes, please, Ron.
Yeah, I don't have any objection, but I think it might read better if when we got to paid according to, and then I would put bracket insert as applicable, colon, and have the, just take out the bracket around pay, the bracket around scale, the bracket around discretion, and then leave the bracket at the end of agency head.
So Gavin, take out the word insert, right? Or is that?
Yeah, that's fine. Yeah, that's fine.
So how should it read, Ron? Are paid according to?
And then the word "the" would have to go back in after
the applicable. Paid according to the applicable.
Paid as applicable, and then following the colon, the pay scale.
Ron, just stop for 1 sec. Gavin, do we have this right on the screen, Reeves?
You need to put the word "B" back in the B.
Ron?
And then you will want either the slash or an or in there. And everything else can be left to the Committee on Style.
Is there objection to that amendment? All right, without objection, the amendment on lines 170 through 173 are adopted, subject to review and possible revision by the Committee on Style. Are there any other amendments, proposed amendments to this recommendation? I'll give everyone just a few minutes here to speak up if they have amendments. All right, hearing no additional proposed amendments, we'll move to a vote on the recommendation. Would voting members please unmute themselves All those in favor of adoption of the recommendation, please say yay.
Yay. Yay.
Opposed, nay. The yeas have it, and the recommendation is adopted. We're going to take a 5-minute break, and the reason we're doing that is for technological reasons in terms of transitioning from one segment to the other. So we will take a 5-minute break and resume at 2 o'clock unless John Siegel is not ready to proceed early at 2. He's good. So we will resume at 2 o'clock. Thank you. Thanks, Gavin.
Standing by. Final set in 5, 4, 3, 2.
Welcome back. I'm very pleased to welcome John Siegel of GW Law School, also a public member, and from about 2010 through 12 or 13 or thereabouts, John was the research director at ACUS. So he's not only an expert on judicial review, but he's also an expert on ACUS. John will talk about the forthcoming source book of judicial review statutes. Before turning it over to John, though, I want to acknowledge the extraordinary amount of research that the ACUS staff, including the staff counsel on this project, Bobby Ochoa, performed for several years. And I'd also like to acknowledge the work of 12 or so project advisors who helped us scope this idea when it was just in sort of an inchoate proposal and before we had retained John. And if you'll just bear with me, I would just like to read their names because they do deserve recognition. Sharon Buccino of the Natural Resource Defense Council, Betty Jo Christian, an ACUS Senior Fellow, Lisa Heinzerling of Georgetown Law School, who was formerly an ACUS public member, Michael Hers, a Senior Fellow of the conference, Kristen Hickman, now a public member of ACUS, Ron Levin, Senior Fellow of ACUS, Dick Pierce, Senior Fellow of ACUS, Jonathan Sallet of Steptoe and Johnson, he was formerly a member of the ACUS Council, Peter Shane of Ohio State, formerly a public member of ACUS, John Siegel, Kate Todd, now with the White House Counsel's Office, formerly a public member of ACUS, Andrew Vollmer, public member of ACUS, and Allison Zeev, a Senior Fellow of ACUS. With that, I'm very pleased to turn it over to John Siegel with my and the conference's thanks for the extraordinary work he's doing on this source book. John, do we have you?
Here, yes. Well, thank you very much, Matt. It's been a very interesting project to work on, and I'm happy to have this opportunity to discuss it for the membership here at the plenary. So to understand this project, I think it's useful to look back first to a previous ACUS project, which was the ACUS Source Book of Executive Agencies. That project was started in 2011, when, as Matt mentioned, I was the ACUS Director of Research and Policy. It was the brainchild of then ACUS Chairman Paul Verkyle, who said, let's examine all the agencies of the federal government. Let's catalog all the agencies and their characteristics. So we'll examine which agencies are headed by officials who serve at the pleasure of the president, and which are headed by officials who have some insulation from presidential removal, which are headed by a single official, which are headed by a board, which are within the cabinet, which are outside the cabinet, which have independent litigation authority, and every other characteristic of executive agencies you could think of. Let's catalog all these characteristics of all the executive agencies. And I have to confess, I was a little skeptical when this project began. I thought, oh, it's just going to be this big table of characteristics. Who'll be interested in that? But it was a very successful project. First of all, Paul recruited some great people to do the project, particularly David Lewis, who's now at Vanderbilt, Jennifer Seelan, she's at the University of Missouri. And yes, the project did produce a big table, but they built a frame around the table. They added narrative commentary that put the information in the table in a useful and interesting context. So that was interesting in itself. And then it turns out that some people really like the big table, particularly some of our friends on Capitol Hill. It turns out it's convenient to them to have this big table in which they can look up the characteristics of different executive agencies. So it was a very successful project. So when Matt approached me for this project, he said, so what we're going to do is something similar for provisions for judicial review. We're going to identify all the provisions for judicial review in the United States Code and make a similar table of all of their characteristics. You know, which ones provide a time limit for review and which ones tell you where to seek review and which ones say something about the standard of review. We'll have a similar big table, and then it will be someone's job, my job as it turns out, to add the narrative commentary that puts the information in the table in an interesting context. So I thought, oh, great, that'll be a similarly great project. So I was very happy to join that project. So what have we done? Well, first we identified all of these provisions, all the provisions in the United States Code governing judicial review of agency action. And when I say we did that, that was done primarily by the staff. And like Matt, I want to take a moment to acknowledge just the extraordinary help I've received from the staff on this project. I definitely could not have done this without the staff. Indeed, I believe on this step, the identification of the provisions for judicial review in the U.S. Code, I believe every attorney at ACUS, not just the attorney advisors, every attorney, so including Matt and Sean, the general counsel, and Reef Bull, the current research director, I think every attorney at ACUS worked on this part of it. So I want to thank all of them. But I would particularly like to mention three of the attorney advisors, Frank Massaro, who was the initial staff counsel on this project, Bobby Ochoa, who's currently the staff counsel, and Jeremy Grabois, who did a lot of work helping with the coding, which I'll come to in a moment. I would particularly like to mention them for thanks in particular. So as I said, so first through computer-assisted searches, the staff identified all of the provisions in the United States Code that govern judicial review of agency action. Turns out there are about 650 of them. And then with the assistance of the Board of Advisors, you heard their names from Matt, with the assistance of the Board of Advisors, we developed a coding schema. We asked the Board of Advisors, you know, if you were to make a big table of all of these provisions for judicial review and all of their characteristics, what characteristics would you want in the table? So we made this schema with the Board of Advisors' advice. And then Jeremy and Bobby and I chose a test bed of about 15 provisions, and we each coded all of them under this schema. And then we compared notes and asked, you know, did we all code them the same way? And what had we learned from this experiment? And as a result of that, we tweaked the coding schema to some degree. And then Jeremy and Bobby went and coded all of the provisions. And then there was some further tweaking and a little more coding. But finally, the result was the master spreadsheet. So this is one of what I regard as the three outputs that this project is going to have. One is this master spreadsheet of all 650 odd provisions for judicial review in the United States Code and all of their characteristics with a value for each characteristic for each provision. So this is one output, and then the second output is going to be the report that I've been putting together about what's in the spreadsheet, and I'll describe that more in a moment. And then finally, as a result of this examination of all these provisions, I noticed a few things which I thought could perhaps be improved. So I've suggested that perhaps this could lead to one or more recommendation projects. Matt asked me to do that, to think as I went through this, you know, what recommendations might come out of this. So I've made some suggestions. Of course, that would have to be approved by the council, so I can't promise that there will be any recommendation projects coming out of this, but there might be one or more recommendation projects as a result. But today I want to focus mostly on the spreadsheet and the report. So what's in the spreadsheet? So as I say, we've got 650 or so provisions, and for each one we have, of course, the citation, and then there's a whole list of columns. There's a description of what the provision is about, what statute it comes from, what agency it involves, some characteristics of the agency. Is the agency in Is it one of the cabinet agencies or within a cabinet agency, or is it outside the cabinet agencies? The table, the spreadsheet shows the text of the provision, when it was adopted, and then lots of things about the provision. Does it provide a time limit for review? Does it say where to seek review? What does it say about the record? What does it say about judicial deference to the agency's interpretation? What does it say about, is a bond required? Is expedition? Is the court to give expedited consideration to the case? What does it say about the standard of review? So there's this whole list of columns, and as I say, for each is a value. Initially, as we first started coding it, each column just had yes or no. Is there something about this topic? But as we worked further on it, we decided it was more valuable not just to say, is there anything about this topic, but at least something about, if there is something, what it is. So we have a system of values that can be in each of these cells in the spreadsheet. So there's this massive spreadsheet showing all these provisions for judicial review and various characteristics of each. So once that got done, I went through, I read all of these provisions. I may well be the only person in the world who has read all of the text of every provision in the whole US Code for judicial review of agency action. And now, as I say, I'm working on this report about what I learned from reading all of these provisions. So I will just mention some of the highlights of what's in the report. Certainly one thing you learn very strikingly by going through all these provisions is how many of them are redundant. Many of them simply say something that would be true anyway. So, for example, a large number of provisions say that the filing of a petition for judicial review of the agency action shall not in itself operate to stay the effectiveness of the agency action. There shall be a stay only if the court orders a stay. Well, of course, that would be true anyway. Did anyone imagine that merely seeking review of the action automatically stays the action? I don't think so. And yet many provisions take the trouble to point that out. A large number of them say the agency's determinations of fact, if supported by substantial evidence, shall be conclusive. Of course, that's a perfectly standard principle of administrative law. Many of them say, if this litigation gets to a court of appeals, the judgment of the Court of Appeals can be reviewed by the Supreme Court on writ of certiorari. Again, of course, that would be true anyway. So there's a great deal of redundancy in these provisions, and I have some thoughts about, is that a bad thing? Should we recommend that this redundancy be avoided? I don't know. I mean, if it doesn't do much good, neither does it do much harm. So anyway, I discussed that in the report. But then turning to things that are not redundant, perhaps the most significant thing that many of these provisions do is set a time to seek review, because if there were no time limit specified on seeking review, as far as I know, the only other time limit that would apply in most cases would be 6 years. There's a 6-year statute of limitations generally on suits against the United States. Evidently, Congress typically desires judicial review of agency action to be sought in less time than that, because usually Congress provides for something more like 30 or 60 days within which to seek review. Also significant is whether the particular statute says where to seek review. Under Section 703 of the APA, if the statute said nothing, you would seek review in district court, which, as the Supreme Court has remarked, is often not a productive use of judicial time, in as much as judicial review of agency action is already somewhat in the nature of an appellate proceeding. And so having it go to a district court and then a court of appeals, when each of those courts would essentially apply the same standard to the agency's action, and the Court of Appeals would not be giving deference to what the district court did, kind of a waste of time. You know, the real function of district courts is primarily to assemble a record, whereas in judicial review of agency action, there's already a record compiled by the agency which is being reviewed. So usually it's not that productive to send it to a district court. Well, a statute needs to say that if it wants to go, if Congress wants it to go elsewhere. Statutes govern what document you file to initiate review. Typically, the statutes either say file a petition for review. Many of them say file a notice of appeal. Interestingly, some of them say file a bill in equity. I was somewhat bemused to find that that still exists, since as far as I know, bills in equity were abolished in 1938 when the Federal Rules of Civil Procedure took effect and merged law and equity. And I don't think it's possible to file a bill in equity in federal court today, and yet there are still some statutes that require you to. So that was somewhat amusing to note. What about serving service of process? How do you serve the document that initiates review, whatever it is? Statutes govern that. Anyway, so there are all these different things I discovered. Let me just mention one more, perhaps the most interesting, I think, of them, which is what the statutes say about the standard of review. What's interesting, I mean, of course, you will not be surprised to hear many of them are redundant. Many of them simply say something like the standard of review in the APA section 706 shall apply. Well, of course, that would be true if the statute said nothing. At the other end of the spectrum, there are numerous statutes that make some clear and effective change to the standard of review. In particular, there are some statutes, not many, but a fair number, that provide for de novo review, including de novo factual review of specified agency actions. So those are clearly distinct from what would apply if the statute said nothing. But what was most interesting to me is there are a substantial number of statutes that make some remark about the standard of review, some specification of the standard of review, which would appear to be an attempt to vary from the standard of review that would otherwise apply, and yet many of these are ineffective. So what am I talking about? Well, for example, numerous statutes say that just one of the standards of review that you would find in section 706 of the APA apply, sometimes in a way that does not absolutely exclude the application of others, but that perhaps does so impliedly. So for example, a statute might say, the court shall overturn the agency's action if it is not supported by substantial evidence. Well, of course, that would be true under 706, even if it wasn't specified in the statute. But one might ask, is the specification of this one provision from 706, is that, and not the others, is that impliedly exclusive? Does that impliedly mean that the other provisions within 706 do not apply? And then even beyond that, there are statutes which say something like, the court shall sustain the agency's action if it is supported by substantial evidence. And that language, if you take it literally, would seem to exclude all the other bases for review in section 706, which would be peculiar. I mean, could Congress really mean by saying the court shall sustain the agency's action if it is supported by substantial evidence, could Congress really mean when it says that the court is to sustain the agency's action even if it is not in accordance with law? Which would be another basis on which agency actions are frequently overturned. If it is supported by substantial evidence, but not in accordance with law, is it really to be sustained? So there are many of these variations in different kinds of wording of the standard of review. And what I discovered by doing some case research, it's one thing to just look at the text of these statutes. It's another to see what the courts have interpreted those texts to mean. Well, doing a little case research, I discovered that very frequently these subtle variations in the standard of review are simply ignored. Either the courts don't notice them at all, they simply proceed as though section 706 was applicable as usual, perhaps not even knowing that there's this variation in the specifically applicable statute. And then in some cases, even where the court does observe that the statute appears to vary the standard of review, the court says, oh, well, and then they just go ahead and apply the normal standard of review anyway, Sometimes there's one pretty well-known case from the DC Circuit in which then Judge Scalia wrote an opinion, and incidentally, Ruth Bader Ginsburg was also on the panel, in which they said, yes, it does seem that Congress has tried to vary the standard of review, but we don't think that really makes any sense. And Section 559 of the APA says departures from the APA have to be stated clearly, so we're just going to apply the normal standard of review. So I thought it was interesting that there are all these attempts to, perhaps they are attempts, to vary the standard of review, most of which seem to be ignored. So one thing I conclude from all this is that if Congress wants to vary the standard of review, it had better do so clearly, because the normal standard has a lot of momentum behind it, and courts are prone to ignoring attempts to vary the standard of review. And then the final section of the report is a checklist. And again, this was something that ACUS specifically asked me to do, a checklist for Congress. So having looked at all these provisions and thought about what one learns by reading all of them, when Congress wants to make a new one, what should it think about? What provisions should it think about including within any new provision governing judicial review? So I have a checklist based on all this reading of the existing statutes. I have a checklist of things Congress might wish to think about as it prepares any new statute governing judicial review. So that's the report. As I say, it's been very interesting. I handed the first draft in last week. The next step, I believe, is that it will be circulated to the Board of Advisors. Well, I think first the ACUS staff is going to take a look at it, and then it will be circulated to the Board of Advisors. So if you're a member of that board, I think you can expect to receive the draft probably next month. And then the project, we hope, will be finished and published next year. As I say, it might give rise to one or more recommendations. And I hope this result will be interesting and useful for ACUS and for the agencies, for Congress, and for the public. So back to Matt. I don't know if we have time. I'd be happy to take a question or two if there's time. I don't know if there's time left in the schedule for that, but back to Matt.
John, that was indeed tremendously interesting, and the book will indeed be tremendously useful. Especially, I hope for congressional drafters on the judiciary committees, in the legislative council's offices, and of course other committees and offices. The report will be published sometime next year by GPO. We will provide each member of ACUS a copy. We will provide each ACUS member a copy, and we will also distribute copies on the Hill, and we will supply however many copies the federal judiciary would like. And as for your draft, John, it is outstanding, as we expected it to be, and the comments are forthcoming, and I hope that you get some useful and helpful guidance from the advisory group. With that, I don't think, John, I don't think we have time for questions because consistent with what we've been doing, we'd like to take a 5-minute break so we can transition to the last item on the agenda. And so we'll resume at 2:30 for the seventh and last recommendation. We'll see you in 5 minutes. Okay, we're back for our last recommendation and final item on the agenda this afternoon. Agency litigation web pages. This comes to us from the Committee on Judicial Review. And I'd like to thank especially the committee chair, Kristen Hickman, our new committee chair for judicial review, and our in-house researcher, Mark Thompson. We'll first hear from Mark on his research, and then we'll hear from Kristen on the committee proceedings. So I'll turn it over to Mark first. Mark, you're recognized.
Thanks, Matt, and thanks to Kristen and the members of the Committee on Judicial Review for all the work that went into this recommendation. The report recommending or accompanying the project is the product of a pretty simple 2-step process. The first thing I did was survey dozens of federal agencies' websites to determine which ones maintained agency litigation web pages, which the report defines as web pages dedicated to systematically cataloging and linking to agencies' litigation materials. Litigation materials are things like agencies' publicly filed pleadings, briefs, and settlements, as well as court decisions, all bearing on agencies' regulatory or enforcement activities. The premise of the project, which was borne out in conversations with agency staff, is that such materials can be extremely useful to the public, as well as to agencies themselves, in terms of enhancing transparency and accountability. My research showed that while a number of agencies do maintain up-to-date and fairly robust agency litigation web pages, most don't. It also showed that there are some features of agency litigation web pages, such as how the materials are organized and the ways users can access them, that bear directly on their value. Those features are covered in the report, and they're reflected in the recommendations that's before the Assembly. The second part of my research involved speaking with the agency officials involved in creating and maintaining a number of the litigation web pages I found in the course of the survey. And so I spoke with representatives from agencies, including the NLRB, the FTC, the SEC, and a number of others. And in the course of those conversations, one theme that emerged over and over again was that agency litigation web pages have to be tailored to the agency's particular circumstances. Because agencies have different constraints in terms of everything from their budgets to their litigation caseloads, to their missions, to their available personnel, and on and on and on. It's important that any prescriptions about agency litigation web pages allow for flexibility to suit agencies' particular needs. You can do that with high-level recommendations, but most of the agency personnel with whom I spoke emphasized the need for a fair amount of agency discretion when it comes to the specifics of creating and maintaining these litigation web pages. The other thing that most of the agency personnel I spoke with noted, and this was consistent pretty much across the board, was just how useful and popular the litigation web pages can be, not just for the public, but even within the agencies themselves. One agency I spoke with shared that their litigation web pages have received hundreds of thousands of unique visitors annually, and also that agency staff regularly refer to the web pages to answer questions posed by the public that go directly to the agency's mission. I know even within ACUS, we routinely refer to agencies' litigation web pages where they exist. And all of that's to say that agency litigation web pages, and by extension this recommendation, can serve a really valuable purpose for agencies and for the public alike. And with that, I will turn it back to Matt and look forward to the Assembly's discussion of the recommendation.
Thank you, Mark, for that presentation and for the really excellent report. I'd like now to recognize Kristen Hickman, who has very patiently chaired the committee meetings on this project, which were, I think, larger in number than I had represented to her that they would be. So Kristen, thank you. I'll turn it over to you now.
Thank you, Matt. Can you hear me?
Yes, we can.
Great. So it's been a very full 2 days, and I'm sure everyone is ready to wrap things up, so I will be brief. First, the recommendation on agency litigation web pages is the product of extensive discussion, negotiation, and compromise. What I thought in July would be a fairly simple and straightforward recommendation turned out to be anything but. We held 3 full 3-hour committee meetings as we worked our way through the terms of the recommendation and its preamble. In between those meetings, we held extensive conversations with representatives from the Department of Justice, the Federal Trade Commission, the Commodity Futures Trading Commission, the National Labor Relations Board, the Securities and Exchange Commission, the Internal Revenue Service, and other government agencies, as well as with public members of the Judicial Review Committee. Many comments and amendments were submitted and debated, including from external groups like the American Association of Law Libraries and the National Organization of Social Security Claimants Representatives. A few agencies submitted extensive markups of the draft recommendations as we went along. Although the committee's discussions addressed a variety of different issues, and I'm happy to talk about any of those in response to questions from the group, and we were able to pin down a number of details in the recommendation itself. One thing that became clear early in the process was the need for flexibility. A number of agencies, as Mark suggested, already have truly useful and effective agency litigation webpage that are exemplars of transparency. I think it's fair to say that the committee felt strongly that we wanted to call agencies' attention to the existence of these existing litigation web pages and to recommend that agencies that do not have agency litigation web pages should give serious consideration to creating them. But the circumstances of agency litigation, as Mark suggested, are highly, highly variable across agencies. What works splendidly for one agency would be ridiculously resource intensive and even unhelpful to the public for another agency. Accordingly, the committee deliberately chose to draft this recommendation to allow agencies more latitude and flexibility than is often the case with ACUS recommendations more generally. And we also wanted to recognize the need for agencies to be able to exercise discretion in designing agency litigation web pages that would work for them, or even to forego doing an agency litigation web page at all, although that would not be the committee's preference. Members of the committee also were cognizant that we are not web designers. So in fashioning the recommendations, we worked hard to strike a balance between offering concrete suggestions and again, recognizing that agency litigations could follow different designs and still be very effective. Before I wrap up, I want to thank everyone who participated in the committee's deliberations for their hard work and the spirit of collaboration and compromise with which everyone approached this set of recommendations. And I also want to thank Mark Thompson particularly, not only for an excellent report and initial draft recommendation, but also for all of his efforts in coordinating the many, many voices that participated in the committee's deliberations. And with that, I'll turn it back over to Matt.
Thank you very much, Kristen. May I ask if Brady Tonsing from the Department of Justice has joined us?
Yeah, I'm right here, Matt. Can you hear me?
Yes, welcome, Brady. This recommendation obviously is of particular interest and implicates the expertise of the Department of Justice. And so I think it's critical that the Department of Justice participate in the plenary debate with respect to this recommendation. The Department of Justice is a member to ACUS, Beth Williams, formerly Assistant Attorney General Beth Williams, departed the Justice Department, I believe, just last Friday. And Brady is here to represent the Justice Department. Under our bylaws, however, only members have speaking privileges, except with the unanimous consent of the Assembly. So let me ask if there's any objection to Brady Tonsing's participation in the debate over this recommendation. Without objection, Brady will have speaking privileges as I recognize him. We'll turn first to the manager's amendment. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. We will now turn to general debate. Do any members of the Assembly wish to be heard? Seeing no request for recognition, we'll turn directly to the pre-submitted amendments, and first the council amendment. The first one is to add a comma after decisions on line 4. May I just turn to Kristen for a sec and ask if you have any objection to the council amendment, or maybe better yet, if you support the council amendment?
I would support this one. I think it was a good catch on the council's part. Thank you very much.
Okay, without objection, the first council amendment is adopted. Let's turn to the second council amendment on line 13. Before may I just turn to Kristen first once more to see if she has any reaction to the proposed council amendment?
No, I think it's perfectly fine. I have no objection to it. And I don't know that I necessarily have any reaction to it other than that it seems fine.
Is there any objection to the second council amendment on line 13? Without objection, the council amendment is adopted. I see that, yes.
Jeff Lubbers has a suggestion.
Jeff cannot be we've already adopted, Jeff will be recognized after we've adopted the council, after we've addressed the next council amendment.
Okay, thank you.
The next council amendment is on page 6. Lines 104 through 106, and the council would propose the addition of the sentence that appears on the screen. Is there a council member who would like to speak to this amendment? Kristen, may I turn to you and ask what you, for your views on the council amendment as the committee chair?
Sure, and I'm just speaking on my own behalf and not necessarily that of any committee members. I don't know that I have a problem with the general sentiment of this additional sentence, but I'm a little bit concerned about the examples that are offered. You know, although court opinions are certainly very important, from the conversation in the committee, my sense is that just as many people thought that particularly agency briefs were as important, if not even more important, than the court opinions themselves. And you know, with respect to pleadings, I'm no litigator, so you know, it's hard for me to say as a universal matter about the relevance of things, but given the range of discussion of different kinds of litigation, I'm a little loath to suggest that pleadings universally are unimportant. So while I have no problem saying that, you know, agencies should some types of litigation materials may be of greater significance, and indeed part of the discussion that the committee held was particularly with agency high litigation, that there might need to use some discretion in deciding which documents to put up there in order that you have so many documents that the web page would become unwieldy. You know, we were particularly loath, I think, to try to come up with any suggestions as to which documents are more important than others.
Is there anyone else who wishes to be heard on the council amendment? Including any council member?
This is David Engstrom. I could be heard on it.
David Engstrom's recognized.
Sure. If we do keep that language in, I would recommend that we say pleadings and papers. At least in civil procedure world, pleadings means something quite specific and a subset of things that are exchanged in litigation. So I would say pleadings and papers. Otherwise, what you're talking about is, say, a complaint and an answer, but not briefing on a motion to dismiss or on a summary judgment.
Emily Bremer would like to be recognized. Emily?
So I have two suggestions on this. The first is that I wonder if it belongs here in paragraph 1 or whether it should be added to the list in paragraph 3 of factors for agencies to consider in deciding whether and what to provide, in which case it could be, you know, the examples could be removed in keeping with what Kristen suggested, just so that it's, you know, sort of flagging for agencies that some of these materials are more important than others. And then the second question I had, which I think is relevant to this, but is also relevant to the amendment that I suggested on paragraph 1, is I'm wondering whether the committee considered the provision. I mean, I don't know if any of the agencies do this, just provide information about docket numbers and litigation, because the preamble talks about the difficulty of just knowing or finding what litigation exists. And it strikes me that a very basic minimum amount of information that could be provided that would address that problem would just be like docket numbers.
Emily, that comment does not bear though on this particular amendment, does it?
Well, I think it does in the sense, it seems relevant in the sense that you might recognize that some are more important than others. And I think the most important thing probably to know if what you care about is access to the information are just basic facts like docket numbers. I mean, those, if we're going to include examples, that would be one that I would suggest should be there.
Okay, recognize Alan Morrison now.
I was a member of the committee, and I agree with Kristen that different people had different views about which documents were more important than others. As far as Emily's point is concerned, if we put up any piece of paper at all, it will have the docket number on, so the agency does. So that will take care of that particular problem. There was actually some discussion early on about court opinions, and various people pointed out that court opinions are actually most likely to be available on courts' websites and other places easily to locate. Pleadings, I think, may be important in some cases, it may not. I mean, you want to know what position the government is taking, and that could be what you're really trying to get at. So I don't, as far as the whole sentence is concerned, I don't care whether it goes in or out, but I would strongly suggest that we not include either such as on the front end or on the back end, because I don't think they're very helpful. And I think many committee members and many parts of the public would find differences of opinion about which are important and which are not important.
John, thank you, Alan. John Duffy is recognized.
I reiterate what Alan said, and I'll just note one other issue, which is timing. The court opinion is only available at the end of the litigation process. You know, even if it's a district court opinion, that could be months or sometimes even years into the process. So I think that and I was on the committee and participated in these discussions. I think that these web pages are most helpful early in the litigation when people want to be notified as to what the agency's position is. So I would either oppose this amendment or if anything, maybe Alan's suggestion of just simply saying that, you know, taking out the such as clauses. Thank you.
Kristen, you're recognized.
So I don't know if the council, and I guess maybe the council can't weigh in here as a collective body, but I'm wondering if we might consider taking some of Emily's points into account as well. If we might consider deleting the such as clauses, but otherwise taking this sentence and moving it down to recommendation 5 as an additional item. Recommendation 5 has, A through G as, giving a full and accurate picture of their litigating positions. We could add an H. And it strikes me that the sentence that the council's amendment, the general sentiment of the council's amendment fits best within this recommendation 5 as perhaps another consideration, suggesting that agencies should recognize that some types of agency litigation materials may be of greater significance than others.
Thank you, Kristen. Usually if we were live, I would just look to the council in the front row and try to gauge the nods and the head shakes and so forth and so on, but I can't do that. I'm just going to ask the council if there's, any council member who objects to the withdrawal of this amendment, and with the understanding that we would return to this issue per Kristen's suggestion. Let me just give the council members 20 seconds or so to see if they have any objection to the withdrawal of the amendment. So seeing no objection, I'm going to withdraw the amendment on behalf of the council, and I'm going to turn back to you, Kristen, for your proposal, and then we'll see what others think of it. Would you mind just summarizing your proposal once more and identifying the suggested placement? Bobby Ochoa already has it up on the screen. Kristen, is that where you were suggesting that it be placed? We can't hear you. Kristen, I think you're muted.
Oh,
Kristen is muted.
yeah, sorry, I got muted. So I'm fine with it being an H. That was where I suggested putting it. I am amenable to putting it anywhere in this list. The one thing I would suggest is we need to delete the term in doing so at the beginning of that item.
That's right.
And perhaps actually in order to make it consistent with the other items on the list, maybe we should also delete agencies should. So it would just begin with recognize. I think that captures the sentiment that the council was trying to get at without preferencing which items may be of greater significance, because that I think can vary from agency to agency and litigation to litigation. So that's my friendly amendment to try to capture the spirit of the council's concern.
Thank you, Chris. And I saw John Duffy nodding. John, may I just turn to you for a second, just ask for you to tell us what you think of the language on the screen?
I follow the fearless leader of the committee.
Okay. Does anybody else wish to be heard? Does anybody wish to be heard on Kristen's friendly amendment, which appears on lines 155 through 56? Jeff Lubbers apparently does. Jeff?
It's just a style point. It doesn't quite fit with the preambular language. Factors agencies should consider are the following: recognize. I mean, recognition of the fact that, or something like that. I mean, there's something that's not grammatical about the way that works. Among the factors agencies should consider are the following: a recognition of, or the fact that.
Jeff, I don't see what you're talking about there. I apologize because we're on number 5, not number 3.
Oh, I'm sorry. Okay, sorry. I take it back.
So does that, it doesn't appear that anyone else seeks recognition on what I'll call the Hickman Council Amendment at lines 155 through 56. Is there objection to the Hickman Amendment on those lines? Okay, without objection, that amendment is adopted. Where are we now, Reeve? Emily Bremmers?
The final council amendment of recommendation.
I'm sorry. We have the fourth council amendment, which is in paragraph 8 on lines 171 through 175. Is there a council member who wishes to be heard on this amendment? If not, I'll turn to Kristen to ask for her thoughts on this proposed council amendment. Kristen?
I think this is fine. I remember we talked about this in the committee, this idea of whether the litigation webpage should be at the subordinate agency level or at the lead agency level, and recognize that it might be variable depending upon the agency and the subordinate agency. And although we wanted to try to avoid telling agencies how to design their litigation web pages, we were very concerned about linking back and forth in this sort of a way. So I think this makes a lot of sense, actually.
Okay. Is there any objection to this amendment? This amendment to paragraph 8? Without objection, the amendment is adopted. So now we'll turn to the now we'll turn to the other pre-submitted, we'll turn to the pre-submitted amendments, having concluded consideration of the council amendments. The first proposed amendment is from Alan Morrison on lines, let's see what line, still 95 through 101. I recognize Alan Morrison now.
Thank you, Matt. As I said before, I was a member of the committee from the very beginning. Well, let me start with the fact that everybody recognized early on that most federal agencies do not have the authority to do their own litigation in federal courts. These cases only involve court litigation. And so therefore, the Justice Department handles these cases. And unless there was some reasonable way for agencies to post these litigation materials, and unless the Justice Department was going to post it for every agency, which seemed highly unlikely and undesirable, even if it happened, that we needed to see how this problem was going to be worked out. And it turned out, after considerable effort, we found out what this paragraph says, which is that in most cases, the Justice Department, when it files in federal court, and today all filings in federal court are electronic, it also designates a lawyer from the agency. It doesn't have to be a lawyer, but it usually is, who will be on the papers and hence would get all notifications of all filings in the case. And therefore, there would be a ready person and ready means available for the agency to have access to all of the court filings, including those by the Department of Justice, as well as by everybody else in the case, so that the goals of this recommendation could be carried out. I drafted this amendment and sent it to the committee, but was not able to attend the last committee meeting. The committee chair and I had some back and forth before the last meeting, and Kristen had proposed some other language, and I can't remember exactly what it said. I thought it was okay. I preferred my language, but lo and behold, the committee came. I had to go to something that was slightly better than a root canal. It was attending a faculty meeting, but I could not be there. And lo and behold, I come to find out that nothing was said about the Justice Department. And my fear is that if this isn't in here, and I assume it's correct, that if it isn't in here, the Justice Department will say it has no responsibility, and agencies will say, I can't get access to this information in order to do it. And the whole purpose of the recommendation could potentially be defeated by people who didn't want to carry out the recommendation simply because they would say it's not possible. If this is correct, and I believe it is correct because we got this information from the Justice Department, then the recommendation is certainly implementable. If it's not correct, and there isn't a means like this, then the entire recommendation is worthless because agencies will not have access, unless the Justice Department goes to the trouble of sending it to them, of all of the agency materials that are filed. And so that is the reason why I proposed this recommendation, and it's in the preamble. Propose this change is in the preamble, and for that reason, I support it. Thank you.
Thank you, Alan. I'll turn it over to. I'm going to turn. Let me look to Kristen first for her response to Alan's proposed amendment.
So I don't recall exactly why Alan's amendment earlier didn't make it out of committee. Maybe another committee member will recall our discussing it, and I just don't remember. I don't know that I have a problem with the sentiment. I'm not. I think there might be a better place in the preamble to put it rather than on lines 95 through 101. It seems to me to be consistent subject matter wise with the paragraph that's on lines 65 through 74. I would actually propose making it a footnote. The sentence that ends in the middle of line 70 might be where I would put that footnote. I also would propose simplifying it a little bit rhetorically.
Well, why don't we start with your proposed simplification, and then we'll deal with the placement. We'll look to, and then we'll go back to Alan to hear his thoughts on the placement.
Okay. Well, I will, for example, I will point out PACER is actually already defined elsewhere previously in the in the preamble. So we can simplify that. But just to break this down a little bit more simply, I would have the amendment read: most federal agencies do not have independent.
Slowly, Kristen, we'll get this on the screen. Just.
Okay, okay,
Tell me
sure, if you want. So most federal agencies do not have independent litigation authority. That's already there. But are represented in court by the Department of Justice. So that sentence is fine. In most cases, comma, these agencies designate a DOJ liaison, comma, who is then added as a recipient for all court filing notices, comma, resulting in automatic access to all filings via PACER. This automatic access should enable.
This, slow down. Bobby's just trying to capture this on the screen. It should read this automatic access, correct?
Correct.
Okay.
Should enable implementation of this recommendation by client agencies. And that's it. It's not dramatically different from what Alan had written. It's just a little bit simpler, and it takes out you know, the whole case management electronic case file system, also known as PACER, which has already been defined.
Let me turn back to Alan for his response to Kristen's reformulation of your amendment. Alan?
I'm fine with the reformulation. I don't care where in the recommendation it goes at this point or earlier. I do think it's sufficiently important that it did not belong in a footnote. And other than that, I'm perfectly okay with it.
Kristen, let me go back to you on the placement. Text versus footnote.
You know, I'm okay with text. It doesn't fit very neatly up in the text anywhere, which is the reason why one of the reasons why, you know, it's kind of backgroundy. I mean, I think some agencies are already aware of this. And so while I take Alan's point that it's good to remind agencies of it, because it's a little bit backgroundy, I think I would be more inclined to put a footnote. It just doesn't fit anywhere with the text. So my preference is a footnote, as I indicated at the end of the sentence that ends in line 70. But if the body would prefer that it be, you know, in the text, I'm not going to throw a fit about it.
Well, I think you're going to have to decide, because I think this is going to be your amendment, Kristen.
Okay, why don't we, then I'm going to propose putting it as a footnote.
Does anybody else wish to be heard on what's now the Hickman Amendment, including Brady Tonsing?
Hi, Matt. Yes, may I be recognized, please?
Please, Brady.
Yeah, thank you very much. I don't know, Matt. I don't object to this language. I support it being in a footnote. I do object to the rationale for it, but I don't think it hurts to have it in at all.
Okay, do you want to be heard on the rationale?
Well, the department is not going to oppose giving its client agencies access to pleadings or other litigation material. And I don't think that in the aftermath of this, our policy will change in any way. We'll support giving our client agencies litigation materials today and tomorrow, regardless of this recommendation.
Would you propose a revision to this language?
No, the language is fine. I don't mind Alan's proposal. I like Kristen's changes to it. I just disagreed with the reason that Alan gave for needing this amendment.
Okay, but you're okay with the actual language.
Yes, I am.
it's always struck me as actually strange that clients don't have access or claim they don't have access to their own litigation materials. I realize the Department of Justice agency relationship is a little different than private sector relationships. In any event here, we seem to have an agreement, and when Alan Morrison and DOJ agree, I think it's probably time to move on. Kristen, do you wish to move this as an amendment? Move the language on the screen to be included as an amendment as a footnote where reflected in the text now.
That is going to be my motion, to have it
Okay.
as a footnote.
Matt, I have a request to be heard.
Okay, Alan, please.
I give up on the footnote point, but I suggest that the footnote go not in the middle of the paragraph where it interrupts otherwise cogent thinking, but at the end of the first paragraph in the preamble, which is by way of introduction, and it seems to me to be appropriate there, or the Committee on Style could move it someplace other than the middle of a paragraph, which it seems to be more certain to get lost than any place else.
Kristen, do you have an opinion on its placement in response to Alan?
You know, with all due respect to my good friend Alan Morrison, you know, I thought long and hard about where it ought to go in the preamble, and I decided this made the most sense. So I'm going to leave it where it is, and if somebody else wants to move that it be moved elsewhere, then they are welcome to, as far as I am concerned.
Okay. Is there any objection to the Hickman amendment? Okay, without objection, the amendment is adopted. Thank you, Alan. Thank you, Brady, and thank you, Kristen. Now we'll move to the next pre-submitted amendment, which I believe comes from Emily Bremer. Emily, you are recognized, and it looks like your amendment relates to, it appears on line or the first sentence of paragraph 1 of the recommendation. Emily?
Yeah, so I suggested making the first recommendation more definitive by saying agency should provide instead of agency should consider providing. And I really hate to be the one to raise this old chestnut. I feel like but on the other hand, I don't know that we've had this fight yet. So it's good we're getting it in. We have to have it in somewhere in every plenary. But when I read that, what I read is we don't really mean that these are best practices. We just mean that you should think about these things. And I don't actually think that that is really in keeping with the recommendation as a whole. I recognize that that Kristen's remarks and introduction perhaps were tailored to speak to the change that I'm suggesting, and I am very interested to hear about the committee's conversations about how definitive the recommendation should be. But I think that even if, and actually I've spent the time since then rereading the recommendation with that in mind, and the context that's provided by the preamble, and also the really, I think, substantial flexibility that is provided in all of the following paragraphs, to me makes a more definitive statement in the opening provision more justifiable. I don't think this is going to put agencies in a position where they feel like they have to do everything, because if you read the rest of the recommendation, it's clear that there are lots of factors to be considered, and that the choice you know, is sort of agency by agency. I guess I have sort of two questions that might bear on my thinking about how definitive we can be, which is the first one is, you know, I recognize that some agencies have a large volume of information. It may not be great to provide everything, and that's recognized in the recommendation. But are there agencies where it really is the best practice for them to just not provide any information at all? Because I think that's the suggestion that comes across from paragraph 1. And then my second question, this is what I raised earlier, is there a possibility, if the concern is resource-based, can an agency just provide a list of cases or of docket numbers? I recognize, as Alan pointed out, that docket numbers are on all the litigation materials, but it seems strange to me that the choice that's presented by the recommendation seems to be between providing absolutely nothing whatsoever or providing litigation materials. Like, was that sort of midstream just a list of case numbers so that people can trace down the documents themselves, something that was considered, and if not, why not?
Kristen, may I turn to you?
Yes, absolutely. Thank you, Matt. So this actually is, I think normally I would agree with Emily about the chestnut about saying should consider rather than just saying should. But in this particular instance, I think this wording was deliberate. One of the things that happened part of the discussion in the committee was the concerns raised by some agencies where they had, where it wasn't quite clear who was going to be providing the information. So there was a lot of discussion about DOJ's responsibility under this recommendation as compared to its client agencies. There was discussion about the Internal Revenue Service and the fact that many, if not most, Internal Revenue Service litigation documents are available on the tax court's webpage. And there's the discussion that we mentioned earlier about whether litigation materials would be provided on a parent agency's website or on a subordinate agency's website. And because of the recognition that we really felt like we needed to provide that sort of flexibility, for agencies to figure out what would work for them, given all of their various circumstances, the choice of should consider was very, very deliberate, I think, in this instance, that we wanted to convey to agencies. Unusually, I recognize for ACUS recommendations, usually we're much more definitive, but in this instance, we were very deliberate about framing this particular recommendation in order to reflect. Sorry, I got distracted by Nina's post in the chat. But in order to reflect the flexibility that we wanted agencies to have in terms of evaluating what would work best for them.
I'll turn back to you in a second, Emily, but Nina Olson put a comment in the text which we need to have come out of Nina's mouth. So Nina, I'm going to recognize you now if you wish to be recognized.
Okay, thank you. I was just following up on Kristen's comment about the IRS and the tax court, because I've been working on a project and trying to get the tax court to disclose more things. They do not make available, for example, their briefs and many of their petitions and things like that on their website. You actually have to physically go there to see the petitions and look at them in person, which is not really a good thing to do in the midst of a pandemic. Or you have to know about the particular document and you can call the court and request it and they will mail you a copy. And they have resisted posting things because they themselves say that they cannot redact people's social security numbers and things like that, although every other court seems to be able to redact that information. So I have concern, I'm just making a point about the lack of transparency that the chief counsel attorneys in the IRS and Treasury have access to those documents, but litigators outside, researchers, et cetera, it is very burdensome for them to get access to those documents.
And this is Kristen. I apologize. Nina's absolutely correct, and I just misspoke in that regard. But there was a lot of discussion about which documents are posted or available where, as regards the Internal Revenue Service as part of our deliberations overall. But that was part of the discussion about the need for flexibility.
Emily, let me turn back to you.
So the only thing I will say in response is that I think that I hear everything you're saying, and I think, as I said before, I think the recommendation provides a lot of flexibility in its very detailed provisions, and that the thing about paragraph 1 is it sets the tone for the whole recommendation. So coming in, reading the recommendation without familiarity with the committee's process, when I read that, the impression I got from it was that this just isn't as much of a priority. That the principle that when possible, this is information that should be easily available to the public, was not one that was being embraced to the extent that I think is appropriate. So while I hear it, I think that given the placement of this language in the very first paragraph, and given the substantial flexibility that's held everywhere there, I continue to believe that that this should be made more definitive. One possibility that could address this is that instead of saying agencies should consider providing access, maybe agencies should ordinarily provide access. Because when it just says should consider, that just says to me, like, this is a thing you should think about, but maybe not actually do. Whereas, should ordinarily give some, I think is consistent with other provisions of the recommendation that identify situations where an agency might not provide information, but doesn't do it in a way that suggests a sort of lack of commitment to the overarching principle.
Brady, thank you, Emily. Brady Tonsing is recognized from the Department of Justice. Brady? Brady? Looks like you're muted.
All right, I don't know, where did I cut off, Matt? I'm sorry, I was doing the space bar and apparently it undermined itself. Can you hear me?
You weren't cut off because you never started. So just start again if you will. Thank you.
The Zoom gives me a space bar exception. Apparently it wasn't working. Okay. So to start from the beginning, I apologize. The DOJ strongly objects to removing this qualification from the first recommendation. I think it would remove the flexibility that was really important to us. As we talked about in the committee and worked with the committee on this, we explained that we have over 30,000 active cases at any one time. So we changing it from should provide to should consider, or from should consider to should provide, it'll lead to, keeping it the way it is with should consider, plus all the factors that we have to consider as an agency in the recommendation, it's going to lead to some sort of litigation webpage. And I don't read it as sort of precluding, an agency's not going to read the first recommendation and stop reading. They have to go forward and look through all those different factors and make all those decisions based on those considerations. And otherwise, removing the qualification it contradicts a preamble. It's going to be impractical, expensive, and as I said before, it'll undermine the flexibility of the proposal that was so important to the department. Thank you.
Does anybody else wish to be recognized, including Emily, the proponent of the amendment? Emily?
Well, one other possibility would be to change it to agencies are encouraged to provide.
Kristen, or would you prefer that I go to Brady on that one, Kristen?
I would prefer you go to Brady. I do think that are encouraged to is better than ordinarily should. But the question in my mind, and let me make clear that DOJ's concerns in this regard were not limited to DOJ, that other agencies with very high litigation were very concerned about this recommendation. And again, this was heavily negotiated and compromised language. But if Brady would be okay with are encouraged to, then I'm certainly okay with it.
Let me look to Brady. Let me turn to Brady now. Brady?
Yeah, I don't think it helps. It's a little bit better, but it's still not going to do it for us. I think all of these factors in this lead-in number one recommendation, they all work together. And I think the flexibility exists in there that Emily's looking for. And I think it leads to an agency making a good decision about what to produce, how to produce it, and making sure the public's kept informed. I don't think we should mess with how all of these recommendations work with each other.
Chris Walker has a way out for us here. Chris, you're recognized.
I don't have a way out. I am going to oppose this, although I like it in theory. I don't want to do something that's going to actually discourage agencies from even looking at the recommendation. And from what I'm hearing, if we tell them that they should provide this or that they are encouraged to provide it, they might actually not even consider the recommendation. So I think at this point, it makes more sense to go with the committee's approach.
Anyone, do any other members wish to be heard on this subject? Give you 10 seconds to weigh in here. Emily,
Yeah, well, Matt,
go ahead, Emily.
yeah,
Please.
I'll just say, hearing no support, I am inclined to withdraw the amendment unless somebody suggests I should do otherwise.
That's because you're a good institutionalist. Thank you, Emily. I mean, I'm happy to put it up for a voice vote, but it sounds as though your preference is to withdraw the amendment, and we'll deem the amendment withdrawn. And we'll turn to the next pre-submitted, and I think the last pre-submitted comment, which is Jeff Lubbers on, well, it relates to the entirety of paragraph 3 of the recommendation. Jeff, you're recognized.
Thank you. Before I just mention my theory on this, I want to hark back to what Nina Olson said. It seems like ACUS might consider in the future a project that related to the transparency and information sharing functions of the Article 1 courts. It's something that, you know, they're sort of on the borderline of the executive branch, judicial branch, but I would think ACUS has never really studied Article 1 courts like the tax court. So that's just a suggestion for the research staff. Now, in terms of my theory on this, Kristen, you might have had a different organizing principle, but when I read these, I thought that in terms of the importance of these factors, D, whether it will advance the agency's mission, should probably be at the top. And then I thought, you know, A talks about, A talks about the benefits, internal benefits, and then I would follow that with E, which talks about the costs, and then you know, then I went on to just reorder the other ones, B, F, G, C, H. So I was just trying to put them in a certain order that made a little more sense, at least to me.
Kristen, may I look to you to respond to Jeff's suggestion?
You know, when it comes to the ordering in which they currently appear on the page, I think that I don't think we had an extensive discussion about the order in which these different items were included. They changed a fair amount over time with respect to the committee's deliberations. And so as a consequence, there may be something of an ad hoc quality to them. I don't have any particular objection to reordering them, although I think on a certain level, I would, you know, if we're going to do it in terms of agency benefits and then costs, I think my inclination would be to put item B, the public's interest in having ready access to certain categories of the agency's litigation materials, a little higher up with the benefits.
Yeah.
Than Jeff's ordering would suggest.
You want to put B first and then DAE?
You know, I don't really care if we go, I'm fine with that. That would be fine with me. I don't have any particular, otherwise, I'm not particularly wedded to the order otherwise.
Okay, well.
First.
Kristen, do you wish to move that as an amendment?
Oh, yeah, I guess somebody has to move it, don't they?
No, nobody does. No, nobody has to move it. If you choose to move it, you may do so.
I guess I'm not seeing a lot of other reaction to it, so nobody else really has any strong objections. So at that point, I have no problem moving it as an amendment.
Okay, does anybody wish to be heard on the ordering of the subparagraphs in 3? there any objection to the Hickman amendment to reorder them as they appear on the screen? As the order appears on the screen in the comment bubble? All right, without objection, that amendment is adopted. Are there any other amendments? Are there any amendments from the floor? We've completed all of the council and pre-submitted amendments. Are there any amendments from the floor?
I do have one.
Okay, Jeff Lubbers.
This goes back to the very first paragraph, the first council amendment that was made. I thought that when they added that comma, it did improve things, but it still seems kind of awkward to me. And so my suggestion would be to say, this recommendation defines as materials bearing on agencies' regulatory or enforcement activities, including agencies' publicly filed pleadings, briefs, and settlements, as well as court decisions. So we moved that last bearing on agencies clause earlier. So I can read it again if that would be helpful. Material.
Can we, is this a matter that should be addressed by the Committee on Style, Kristen?
No. Can I be heard, Matt?
I don't know who's talking.
This is Jack Bierman.
Well, hold on, Jack. Let's get the language that Jeff is proposing up on the screen. And then we'll.
That's it.
All right, it appears on the screen as you wish it to appear on the screen, as you want it rephrased, right, Jeff?
Yes.
Okay.
Now Jack can take it apart. He can take it apart.
Yeah.
Jack, hold on, Jack. Do you wish to be recognized on the revision to lines 3, 4, and 5?
Yes, sir.
Okay, please, go ahead.
Yeah, that revision completely changes the meaning and the scope of the recommendation, because we're not asking for all materials bearing on agencies' regulatory or enforcement activities. This is focused on litigation materials. And so I think that the amendment is just completely, it's just completely off base, unless I'm totally misunderstanding this.
Well, so let me ask a question.
Jeff, hold on, Jeff. Jeff Lubbers is recognized.
So under the language before I tried to change it, it says as well as court decisions, comma, bearing on agencies' regulatory or enforcement activities. So
yeah,
if you have that,
Jack, please. Jeff, are you done?
Yes.
Jack Bierman is recognized.
It should, in my opinion, it should go back to the original with the comma deleted. That's the correct meaning of the thing. Court decisions bearing on agencies' regulatory or enforcement activities. In my understanding of this, when I read it, that was only referring to the court decisions, not to the rest of the thing. This is not a proposal involving the broad issue of agency regulatory and enforcement activities. That would be a completely different proposal.
Kristen is recognized.
I agree with Jack Bierman on this one, that moving the clause as it does substantially broadens the definition of what is covered by this recommendation. And again, this was a definition that was heavily negotiated and the subject of a fair amount of compromise. So, as it originally read, bearing on agencies' regulatory or enforcement activities modified pleadings, briefs, and settlements, as well as court decisions. Whereas if we move that language, as Jeff Lubbers suggests, then the modifier becomes the focus, and we expand dramatically the universe of documents that might be covered by this recommendation. And to the extent that there was so much concern about the scope of the recommendation and so much discussion about the precise definition of agency litigation materials. And I will point out that if we change it here, we have to change many other instances throughout the document where we rely on this definition and refer back to this definition. Many of those precise wordings had been heavily negotiated. So this really upsets the apple cart, making this change.
Okay, I would like to I will recognize now Don Elliott, who's been waiting patiently. Don?
Be very brief. I was a member of the committee, and I agree with Jack and Kristen. With all due respect to my friend Jeff Lubbers, I think we should stick with the original language.
So may I respond, please?
No, Jeff, hold on. There are other people who seek recognition, and I want to ensure that they be recognized.
But you've misunderstood.
Jeff, please. Jeff, I'm sorry, but there are other members who seek recognition, and I have to be even-handed here. Ron Levin is recognized.
I was just suggesting that I agree with the substance of Jack's position. I understood Jeff's position to be grammatical, and it might be more grammatical to say defines as agencies publicly filed pleadings, briefs, and settlements and court decisions where such materials bear on agencies' regulatory or enforcement activities.
Jack Bierman would like to be recognized, and then I will turn back to Jeff. Jack?
Yeah, I would. I think what Ron just did is similar to what I would prefer, but I think just take out the "and" before settlements, and then say court decisions, and then take out the comma before bearing. Take out "as well as." I don't know why there's "as well as." We're in a list. And the reason is I didn't understand bearing on agencies' regulatory enforcement activities to modify everything in the list. And if it does, then I think that's the most grammatical way to say it, including agencies' publicly filed pleadings, briefs, settlements, and court decisions, briefs, settlements, and court decisions, comma, bearing on agencies' regulatory or enforcement activities.
Kristen, let me turn back to you.
Sorry, problems unmuting. Actually, Jack's suggestion is not precisely grammatical because agencies don't have court decisions. Agencies have publicly filed pleadings, briefs, and settlements that are their documents.
Right.
And then court decisions are prepared by someone else. So that's the reason why it's worded the way that it is. I don't know that I have a problem replacing bearing on with where such materials bear on. That strikes me as 6 one way, half a dozen the other. So that one I think is fine, but I oppose the Lubbers amendment otherwise.
And you would prefer, Kristen, that the text stay as it is with the added the comma added by the council?
Yes, leave the comma added by the council because I think that was a very good addition that fixed a problem that we didn't notice. But I do think that we have to have court decisions set apart with "as well as," because all the other materials are prepared by the agency, whereas court decisions are not.
Okay, Jeff Lubbers is recognized now.
Okay, I wasn't trying to change the meaning of this at all. I was just trying to be more grammatical, as Jack said. And he led off by saying he thought that the addition of the council's comma was a mistake. And I sort of thought so too at the time, because I couldn't figure out, I thought that the phrase bearing on agencies' regulatory and enforcement activities was intended only to modify court decisions. And if that's the case, you didn't need the comma there. But the way it is now is closer to, you know, I mean, I don't have a real problem with it the way it is now, but I mean, I just didn't understand when I was agreeing with Jack that the comma, the addition of the comma seemed to have changed the meaning. So I'm happy now. I mean, it's fine with me now.
So, Kristen, we should revert to the original.
I think so. You know, with the possible exception of Ron Levin's suggestion.
Let's hear from Ron. Can we hear from you once more?
Whatever Kristen wants.
Pardon? I didn't catch that, Ron. Please, could you
I'll
repeat that?
support whatever Kristen wants.
Okay, that's very helpful. Kristen, what do you wish for?
I guess this is whatever Kristen wants day.
It's whatever Kristen wants because it's now what time is it now?
Sure,
It's
it's 2:30.
3:35.
Well, 3:35. I'm an hour earlier. I think where such materials bear on. Here, not seeing any objection by anyone else, and I can appreciate that grammatically that might be easier to follow.
Ron,
But
do
thank you to
you,
Ron Levin for the suggestion.
Ron, you like what's on the screen now?
I think that's what I proposed. Yes.
Kristen, do you wish to move this as an amendment?
Sure, I'll move it as an amendment. And actually, let me say one more thing. I think having bearing on agencies' regulatory or enforcement activities as a modifier of all the items on the list makes a lot of sense because that's what people are interested in. Not everybody cares about, when agencies get sued over random stuff that doesn't have any impact on the public. So I think that was our emphasis. It's not just court decisions that bear on agencies' regulatory or enforcement activities. It's agency litigation documents that bear on agencies' regulatory or enforcement activities. So that modifier, I think, is deliberate for the whole list.
And I think it's consistent with the project description and generally the project proposed by the council. Isn't that right, Reeve? Reeve is nodding. Any objections to the Hickman amendment reflected in line 4? Without objection, the Hickman amendment is adopted. I see here that Brady Tonsing may have a comment or a proposed amendment to what's now the amended line 4. I'll recognize Brady.
Thanks, Matt. Thanks, Kristen. I'm sorry, I was a little slow on the gun there.
I might have been a little slow myself, so we're both slow.
It was just a minor point, and if it had already passed, I wouldn't have raised it. But maybe instead of bear on, reflect or represent, where such materials reflect or represent agencies' regulatory and enforcement activities. And I offer it if Kristen, because it's her day, does not like it, I withdraw it.
Kristen?
I really wish somebody else would weigh in here with some thoughts about whether that changes meaning.
I would only do reflect or represent interchangeably, not both of them.
I think I prefer bear on because I think reflect or represent is just a little bit too narrow. And bear on strikes me as a touch broader. And while I appreciate the desire not to be too broad, I don't think bear on is overly broad.
All right, I withdraw it.
Thank you, Brady.
Thank you, Brady. Renee Landers, do you wish to be recognized?
Sure. I wasn't a big fan of the bear on language, but so I was just proposing relate to, but again, if Kristen doesn't like it, then we can get rid of that. I was just trying to do something to respond to the reflect or whatever was the last suggestion.
Kristen, what is your preference as between bear on or relate to?
I'm okay with relate to.
Is everybody else happy with relate to?
No, I have a concern with it.
Wait, is that Don Elliott?
Yes.
Okay, Don Elliott is recognized.
Thank you. I'm just concerned that relate to will be interpreted by agencies as saying they have to post everything that describes or is in connection with one of their policies or rules. I think we have to be careful that we don't unintentionally make this more onerous than it needs to be.
So Don, you would prefer the phrase bear on rather than relate to?
Yes, I would stick with it. It may not be perfect, but I think relate to is too broad.
Kristen, you have no strong preference here?
I do not have a strong preference. I will make the observation that there are so many qualifications and considerations and caveats in this recommendation to provide flexibility and discretion to agencies that I'm not sure that it would make a huge difference. But at the same time, if somebody feels very strongly about relate to as opposed to bear on, I'm fine with bear on. It's not perfect, but I was fine with it to begin with.
Okay, Bobby, could you put bear on the screen, remove relate to? Is there a voting member who wishes to move an amendment on this point? Are there any other proposed amendments from the floor? It appears there are none. We'll give everyone another 10 seconds and then we'll proceed to a vote on the recommendation. Okay, let's proceed to a vote on the recommendation. If voting members will unmute themselves. All those in favor of adoption of the recommendation, please say yay.
Yay.
Opposed, nay. Okay, the yeas have it and the recommendation is adopted. With my thanks to Mark and Kristen, not only for chairing the committee proceedings, but also for comporting herself so well, if you will, during the plenary session debate. Thank you, Kristen. We really very much appreciate it. With the adoption of that recommendation, our business comes to a conclusion. I want to thank all our members for giving the conference their scarce time at this plenary session and throughout this challenging and trying year. I also want to thank our staff, and if we were live, I'd ask them to stand and be recognized and receive your applause, but we'll have to do without that. I'd especially like to recognize two members of the staff whose names I don't think have been mentioned throughout the plenary session, but are for obvious reasons integral to our operations. And they are Harry Seidman, who's our CFO and COO, and Sean McGibbon, of course, who's our general counsel, and she is known to many of you. So thank you, Harry. Thank you, Sean, and thank you to the rest of the staff. With my thanks again to all of you and my very best wishes for a happy holiday season and a happy new year, I adjourn the 73rd plenary session of the Administrative Conference of the United States. Have a good evening.